না আমাকে যদি বলে যে আর কি হচ্ছে হ্যাঁ এবার সত্যি কথাই মাঝে একটা দিন আজ আর কাল শুক্রবার ধরুন শুক্রবার হয়তো বলতে হবে
গ্রুপ কিন্তু ওই সপ্তাহে ছিল
জানি তো গ্রুপ কয়েকটা নিয়েছেন তো ওই লাখটিয়া করেছে
হ্যাঁ
লাখটিয়া করেছে প্রথম দিকে যে কটা ঢুকে গেছে ওপরের দিকে সে কটা তারপর থেকে আমি লক্ষ্য করে দেখবেন একটা
এই সপ্তাহে
একটা ওষুধ পৌঁছেছে দেখুন না
আপনার গ্রুপ ফোর রেভিনিউ
এবং একটা ম্যানেজার অর্ডার নিয়ে দিয়েছে আর তুমি ওই সপ্তাহে ছিলেন ও ম্যাটার ডিসপোজ হয়েছে অর্ডার নিয়ে বেরিয়ে
I'm a petitioner and person. I'd like to move my matter, which is listed as item number 65. It's a deed matter, actually. I have filed this application against the respondents. Actually, the respondents are government enterprise, WBSC TCL. The respondents have carried out a government project regarding transmission of electricity. And while carrying out this project, they are violated by legal rights as well as fundamental rights.
Who are you? Are you an employee of WBSC DCL?
No, I am the petitioner.
You are the employee, are you an employee of WBSC DCL? How you are attached or connected to WBSC DCL?
No, they are my respondents. WBSC TCL are my.
How you are connected to WBSC DCL?
Actually, they have carried out a transmission project on my land, on the land on which I have interest.
So land has been encroached by the WBSC DCL,
They have,
for which you have approached this court.
yes.
So it is appearing in the list in usual term. If it is taken up, all matters are added.
Actually, I am coming from Coachbihar. It takes 100 kilometers of balls, and I came last 2 consecutive days. That due to adjournment of this matter court, I could present my case. So I submit that you kindly allow.
So the other matters where petitioner is not appearing in person, they have engaged their learned advocates. What wrong they have committed?
I'm not saying.
So therefore, it will be taken up serially. Unless until it is extremely urgent matter, if you could satisfy me that this matter cannot wait till Friday, then definitely I would have accommodated your matter.
No, so I would like to say.
Out of turn. But if it is not so much urgent, then you have to follow the serial number.
Kindly let's.
Yes, any other mentioning?
But maybe
Your Lordship, earlier the matter was mentioned before the bench, Your Lordship, and Your Lordship was directed to fix on Monday, 10th of July, Your Lordship. But due to unfortunate reason, Your Lordship, the matter has not come till now, Your Lordship.
Yes, please. Monday আসতে বলেছিল sorry, you give the mentioning slip. I don't know when it will be, because there are 2 days. 2 days left. Yeah, what is the urgency? Yes, what is the urgency? Yes, Mr. Counsel, what is the urgency?
Your Lordship, this is a matter related to the rectification of sale deed, Your Lordship, and the petitioner.
Wait, maybe it can be taken up in this circuit. I will try, but I don't know how far I can reach today, considering the length of the list. Let me see.
Beautiful.
Restoration application, when it was dismissed for default.
Last side,
Next circuit, sorry, please.
Mayor, for me to mention, my lord, on the last occasion, on the last circuit, my lord, there was a direction, my lord, for to the state respondent, my lord, to file affidavit, my lord, opposition. Well, till date has not been filed, my lord. I am on behalf of the my lord, Jila Porishad. The petitioner, my lord, has filed a writ petition challenging, my lord, the recruitment rules. My lord, due to the pendency of this writ petition, my lord, the entire recruitment process, my lord, is in, my lord, court.
So let them file their affidavit. What you are asking for?
Direction by my lord, Justice Krishna.
Yes, very well. Then what you are asking for?
My lord, the direction was to the state respondent, my lord.
To file affidavit.
Affidavit.
So let them file their affidavit. Why? What you are praying for?
No affidavit in opposition is pleaded.
So you send letter, then you mention the matter. If affidavit's time is over for hearing, affidavit is not filed.
But there is a parentary
This
direction.
court cannot compel the parties to file affidavit. Keep it in mind. So after the expiry of the time, if affidavit is not filed, you take steps for hearing of the matter. Yes, any other mentioning?
but may I be permitted to mention? But one matter, my lord,
Just a minute, yes.
I am liberty to mention a matter. In the last circuit, there was an order that the matter is supposed to appear in the next circuit. My lord, but it has not appeared in during this time. That is why my lord, I mentioned in this matter.
Hearing or motion?
My lord, motion.
Motion.
My lord.
What is the matter about?
My lord,
What is the
it
argument?
is a group 4 matter, and there is a demand that is staring at my.
You have mentioned I have refused your prayer
My lord,
previously. Sorry, next matter. Any other mentioning? No further intrusion now.
Yes, any other mentioning? E-mentioning item number 1.
My lord, may I be permitted to, my lord, mention, my lord, here, for putting this matter as to be mentioned, my lord, subject to lordship's convenience, my lord. But this matter, my lord, pertains to, my lord, the renewal of, my lord, license, my lord, of the license.
Motion? Is
My
it
lord,
a
it is,
motion?
or I tell you, lordship, my lord, this has been, my lord.
Motion, Mr. Rai?
Yes, my lord, this has been, my lord, dismissed at initially, my lord, at the stage of hearing. And after that, my lord, that was, my lord, the honorable single bench's order was set aside by the honorable division bench's order. And my lord, the honorable division bench was pleased to, my lord, direct the honorable single bench, my lord, to hear this matter afresh. And after that, my lord, on the previous circuit, my lord,
Affidavits?
my lord, there were previous direction for filing of affidavits.
Not now,
Now,
sorry, sorry.
the problem, my lord, the urgency, my lord, I was saying.
Sorry,
only
not
one
at this stage, sorry. Mention before the next circuit. Any
But,
other on emo? Any other mentioning on emo? Item number 1 for appendix side, delete was placed.
My lord, I am appealing for the municipality, Kuch Bihar municipality.
Yes.
But can it be post when the date for keep being
Why you have mentioned this matter about inclusion of the list under the heading
inclusion of the list for non-prosecution. Yesterday the matter was on the same meeting on the same number. But I pray before your lordship, my lord, for withdrawal of the petition, my lord, with liberty to file fresh. Right? And my lord, your lordship, my lord, was pleased to, my lord, visit my application that withdrawal will be permitted, but leave at this stage, yes. And my lord, on the last condition, my lord, I pray before your lordship that I have to, my lord, take instruction from my client. Yes. So, my lord, that was, my lord, I could put you, my lord, take instruction from my client, my lord, as because.
Then I have to record that you have prayed for and I am refusing your prayer. So that there would not be any forum shopping.
Lordship.
Yes, lordship. Yes, sir.
My lord, I am appealing for the respondent number 3 to 6.
Very
Those
good.
are the Kuch Bihar municipalities.
The matter has been accommodated in the list on being mentioned by the learned advocate representing the petitioner. Under the heading to be mentioned, quote unquote. Stop. Next paragraph. At the time of consideration of this matter, learned advocates representing the petitioners and Kuch Bihar municipality are present. But the learned advocates representing the petitioners, Kuch Bihar municipality and the state respondents are present. Stop. Next paragraph, the learned advocate representing the petitioners has prayed for withdrawal of the writ petition on the ground of non-prosecution with a lead to file afresh on self-sent cause of action. Stop. Next paragraph. This court has perused the orders passed by the coordinate benches on this writ petition, and it appears that on 12 July 2022, a coordinate bench passed an order directing the Kuch Bihar municipality to depute competent officials to inspect the disputed property with prior notice to the petitioners and the private respondents, and a report to be prepared, which is to be placed before this court on the next day. Next paragraph. In consideration of the order passed by the coordinate bench on 12 July 2022, this court has refused the prayer of the petitioner to grant leave to file afresh on self-sent, to file another writ petition afresh on self-sent cause of action upon withdrawal of the present writ petition. Stop. Next paragraph. On expressing mind of this court, on expressing my mind to the learned advocate representing the petitioner, it has been submitted, representing the petitioners, it has been submitted on behalf of the petitioners that let the matter be placed before the next circuit, subject to convenience for hearing of the writ petition on merit.
Grateful, your lordship.
Item number 2. No, it has come from the department for correction. Issue. Hey, Shobha. The matter has come up in the list at the instance of the department for correction of the order dated 4th July 2023. Stop. Next paragraph, it appears that in the cost title of the order dated 4th July 2023, title of the petitioner has inadvertently been transcribed as BHA PTA CHA RYA, BHA PTA CHA RYA, quote unquote, instead of BHA TTA CHA RY. First, যেটা বললাম সেটা BHA TTA HARYA, সেটা পড়ি BHA TTA HARY. First, instead of BHA TTA CHARY, সেটা missing আছে. The name of the writ petitioner in the cost title of the orders dated 4th July 2023. Name of the writ petitioner, the title of the writ petitioner in the cost title of the order dated 4th July 2023 shall be read as BHA TTA CHARY. Stop. Next paragraph. The department is directed to incorporate necessary correction in the order dated 4th July 2023. Stop. Next paragraph. This order forms part of the order dated 4th July 2023. Next.
Item number 3, extension of interim order.
Item 3, my lord, I am for the writ petitioners, my lord.
Yes.
You know, order was passed, my lord, on 16 June, my lord, 2023, with regard to, my lord, some illegal construction which was going on, my lord, in my lord, tea garden. The tea garden, my lord, is leased to me. My lord, the order still.
With
No,
regard to the construction.
no, my lord, in a tea garden, my lord, which is leased to me. My lord, the court has found a prima facie case in my favor.
You are the lessee of the tea garden.
Yes, my lord. Yes, my lord.
Yes. Then.
It's a 30 years lease.
Yes.
Now, my lord, without my authority, my lord, the state wanted to, my lord, carry on, my lord, construction of a road through my tea garden. My lord, this was found to be, my lord, illegal, my lord, at the prima facie stage, and an order of, my lord, injunction has been passed restraining them, my lord, from doing any construction. That order till 12th July. Directions were also given, my lord, for filing of affidavits. No affidavits have been filed. So, my lord, I will.
My lord, I am the respondent number 8, the contractor. In the previous occasion, Lord, I was absent during the hearing. Service was not completed.
Just a minute. Here, Mr. Banerjee, this order, interim order was passed initially on 16 June 2023.
Yes, my lord. Yes, my lord.
Now, the main contesting authority is the state respondents.
Yes, my lord. Yes, my lord. They're the ones, my lord, who had issued a work order.
So today you are seeking extension of that.
I'm seeking for extension, my lord. They have not filed, my lord, any affidavits, my lord, with directions were given.
Well, let me hear the other side. Yes, you are representing which one?
Respondent number 8, you are the contractor, who was awarded the contract. I'm not on the earlier occasion. But the service was not complete upon me, Lord. I was absent, and Lord, in my absence, the interim order was passed, Lord. But consequently, I have filed a vacating application to Jan 1 of 2023. Now, Lord, there are
Whether this vacating application is appearing today?
yes, Lord. Jan 1. Now, yes, few facts you have to place before your Lordship, Lord.
But today this application is not for application matter has been accommodated in the list.
I
You
understand.
have to take steps for hearing of the vacating application.
I understand.
Before the
And your lordship allowed by
vacating application. Yes, yes.
Now, Lord, no, I appreciate my case, Lord. Few facts need to be placed before your Lordship. Lord,
Now, Mr. Counsel, today this court will not consider the vacating application for a short period. This interim order will be extended.
Lord, I am
My lord, there's also.
actually.
Yes.
I'm sorry, my lord, there's also an application for extension because the state, my lord, is really the right respondent because, my lord, the contractor can't have a right.
The main authority who have
Yes.
mooted the project of.
Yes, correct. Absolutely, my lord. I'm grateful.
And they are the beneficiary of this.
Yes. And, my lord, they have not filed any affidavits.
Yes.
Now,
Where is the
I
affidavit?
have somebody in the
2 weeks' time, my lord, is gone. Up to the 30th June, my lord, affidavit directions were given.
our affidavit will not be spending, that is right. But we are also supporting the cause of the contractor.
But why you have not filed affidavit within time?
We are due to the pending election, if the officers were not available, we will file the offense. Not that we are questioning happy over it. But we are the entire interim order, if you are kindly goes through it, that it has been delivered, we are products on the wrong premise, or not completely appreciation of facts. Where the case has been canvassed and see a new road is being constructed over a TSN by demolition and uprooting of tree bushes, which is absolutely not the case. Where we have the can referred by the contractor is served upon us, so that we have gone through it. We are the spiritual of photographs. It's a road which is not existing since decades. You connect a small pocket of tribal households. And I don't know why the garden of people are objected to it. The project was only to lay a layer of concrete over that existing road.
So these things have to be, since an order has been passed by the coordinate bench, these things have to be put on record.
Yes. And state,
On behalf of the state respondents.
state was represented on 16th June.
Yeah, the respondent number 8 is the contractor. Here, the court is not desirous to hear these things from a contractor. The court wants to hear these things from the state. So let the application very well file an independent affidavit to this writ petition, within which time we will be able to file the affidavit. Tell me.
One more fact, the work against which an interim order has been obtained. 90% of the work is complete. All those facts they have.
Very well, I take a short date. Within which time you will be able to file your affidavit?
I appreciate my case, not just for.
Within which time?
Within 7 days.
Very well. And I will direct the petitioner to file their affidavit to the vacating application within 7 days. Reply thereafter, the application along with the petition to be heard by the next survey.
I'm grateful, Manoj.
1 week, 1 week, 1 week, 1 week, and interim order is to be extended for 3 weeks.
Can be places it will on the first day of the next circuit. To the next circuit.
Yes, yes. Because this court wants to hear these things from you, not from the contractor. Contractor is the beneficiary of the tender. They are not supposed to put on records these things. Yes, they have come up because they have been affected, or the respondent number 8 has been affected due to the subsistence of interim order. They have the right, or the respondent number 8 has the right to come up with an application, vacating application. But court is desirous to hear these things from me. Put these things on affidavit, let the matter be heard. The writ petition is accommodated in the list under the heading extension of interim order. Under the heading extension of interim order, on being mentioned by the learned advocate representing the petitions. So, at the time of application, why 2 applications are there?
Well, there's one application for extension as well, Manoj.
One is for extension, another is for
Vacating.
vacating.
Can one is still their recalling application.
Oh, one is for extension, file an application.
Yes.
Can 2 is for vacating?
No, can 2 is for extension.
Can one is not for vacating.
Yes. 2 applications are being can 1 of 2023 and can 2 of 2023 are taken up by the respondent number 8 and the writ petitioners respectively. So in can 1 of 2023, respondent number 8 has prayed for vacating has prayed for vacation of the interim order. It is 16 June 2023, whereas in can 2 2023, petitioners have prayed for extension of interim order passed by the coordinate bench on 16 June 2023. Stop. Both the applications are also considered today along with the prayer of the petitioners for extending the interim order passed on 16 June 2023. Stop. Since no affidavit in next paragraph, since no affidavit in opposition has been filed on behalf of the state respondents, and a prayer has been made on behalf of the state respondents to grant 7 days time to file affidavit in opposition to this petition, let the interim order passed by the coordinate bench on 16 June 2023 be extended till At that, when the next circuit will commence? 31st July. We expect. Just like.
मतलब क्या बोलते हैं मतलब
Till 11th August 2023. Stop. In the meantime, state respondents are, in the meantime, respondents in the writ petition shall be at liberty to file affidavit in opposition to the writ petition within 1 week from date, and reply thereto if any be filed within 1 week thereafter. Stop. Next paragraph. The application for extension of interim order filed by the petitioners being Can 2 of 2023 stands disposed of. Stop. Next paragraph. This court has heard the application of the respondent number 8 seeking vacation of the interim order dated 16 June 2023, and this 2023. Stop. Parties to this vacating application shall also be at liberty to file affidavits. Stop. Let affidavit in opposition to this vacating application be filed within 1 week from date, and reply thereto, if any, be filed within 1 week thereafter. Stop. Let the vacating application be taken up for consideration along with the writ petition on the next day. Stop. Let the next paragraph. Let the writ petition along with the vacating application be listed before the second day of the next circuit, subject to convenience of the bench.
I'm grateful.
Yes. 2 weeks will be concluded on 26th July. 31st it will commence. Appearance দিয়ে যাবেন।
Grateful.
Item number 4, under the new motion heading, inclusion 1. Evidence, sir.
Yes. That's it. Who is for the state? Yes. Retired.
31st July 2018.
31st July 2018.
Yes.
Then
Because that
what is the matter? Revised PTO?
no. Withdraw, overturn.
Overdrawn amount. How much amount?
About this 57,173.
57,173. Yes.
Deposited by the channel.
57,173. Retired. Then when PPO?
PPO was issued in on
Date?
2nd May 2019.
May 2019.
Yes.
So you want what refund of the overdrawn amount? 57,173. Let an order be passed, Mr. Shah. Affidavit of service filed in court is taken on record. Next paragraph, petitioner was an assistant teacher of primary school who retired on superannuation on 31st July 2018. Stop. After the superannuation of the petitioner, while processing the retirement dues, respondent authorities calculated rupees 57,173 as excess drawn amount, comma, which petitioner was directed to refund before release of retirement dues. Stop. Petitioner deposited the said amount with the appropriate authority, and the treasury challan was issued in favor of the petitioner showing such deposit. Stop. Subsequently, comma, pension payment order was issued vide memo dated 2nd May 2019. 2nd May 2019, releasing retirement dues. Stop. Petitioner claims refund of alleged excess drawn amount which he had to deposit at the time of processing terminal benefits. Next paragraph, it is submitted on behalf of the petitioner that at a time of processing terminal benefits under the garb of excess drawn amount, no amount can be demanded by the respondent authorities. Stop. It is also submitted that this is not a case of misrepresentation and fraud by which petitioner's wife managed to receive the said amount during her tenure. Next paragraph. No, the last sentence is to be changed. It is also submitted that this is not a case of misrepresentation and fraud by which petitioner managed to receive the said amount during his tenure. Stop. Next paragraph, the learned advocate representing the state respondents has defended the decision of the respondent authorities on demand of deposit of alleged overdrawn amount. Stop. Next paragraph. Having considered the submissions made by the learned advocates representing the parties, it appears that the issue of demand of excess drawn amount after retirement at the time of releasing terminal benefits is no more res integra in view of the judgment of the apex court reported in 2015-4, volume 4, 2015, volume 4 SCC 334 within bracket state of Punjab and others versus graphic machine within bracket whitewasher bracket close and others. Semicolon, paragraph 18 of graphic machine supra is quoted below. 18 different pages are Next paragraph. In view of the aforesaid decision of the apex court, this court finds it apposite to direct the concerned respondent authorities to refund the amount deposited by the petitioner on demand after his on demand at the time of processing pension case of at the time of processing his pension case. Stop. Next paragraph. Accordingly, comma, treasury officer being the respondent, which respondent? Treasury officer 4. Being respondent number 4 is directed to refund the amount deposited by the petitioner within a period of 12 weeks from the date of communication of this order. With the above prediction, the comma, the written petition shall disposed of, there shall be no others to cost or this way. Okay. In number 5. Yes.
Yes, the petition is claiming that this was applicant in a confirmed video petitioner that video of that.
Just give me the particular petitioner was teacher. Husband. Died in harness or after retirement? Husband. Just when died in harness?
11th October 2012.
2012. In harness. He was working as
Assistant teacher.
high school.
Assistant teacher. Okay, 5 minutes.
Then what happened? wife of the petitioner received the benefits by PPO. Give me the date of PPO.
2nd February 2015.
First PPO,
Single PPO.
single PPO. 2nd February,
2015.
2nd February 2015. Now, what do you want? Interest on that? PPO was issued on 2nd February 2015. Otherwise, 2012 is the, what is the PPO? Where you have annexed the PPO? Yes, 2nd February 2015 PPO. Let an order be passed. Affidavit of service. Husband of the petitioner was a primary teacher who retired, who died in harness on 11th October 2012. Yeah. Stop. After death of the husband, petitioner being the wife of the deceased teacher received terminal benefits on issuing pension payment order dated 2nd February 2015. Stop. Petitioner claims interest on gratuity due to delayed payment. Stop. Next paragraph. State respondents are represented by learned advocates. Stop. Next paragraph. Accordingly, the Director of Pension, Provident Fund and Group Insurance and the concerned Treasury Officer are directed to pay interest at a rate of 8% per annum to the writ petitioner on the gratuity from the date following the date of death of the husband of the from the date following the date of death of husband of the petitioner till the date of disbursement of gratuity, comma, within a period of 8 weeks from the date of communication of this order. Stop. The rest of the paragraphs will remain same. This posted.
Item number 6.
All right.
Yes.
It's a matter relating to cohort. Here, the husband of the petitioner is the assistant teacher, retired from service 31st August 2015.
Just give it a show. With the extension of the last date of the next circuit. The second number next circuit something only extend for the because July to 31st July 11 hours of the extended. 11 $11 until is yes. Yes. What is the matter? Yes.
Claiming the impact of the overall
Refund. How much amount?
The amount is 1,91,520.
Representation.
I have to
When retired?
Retired,
Just a minute. Petitioner himself was an employee. Why? Then petitioner died after retirement or before retirement? Husband. When died?
No, retired on 31st August 2015.
Retired
31st.
August 2015.
And pension payment order was issued on last December 2016.
BPO dated first,
September 2016.
yes, when died,
Died below 22nd July 2021.
yes. This is the case you are seeking refund of the amount.
1,91,030.
185, 141.
41 and below 16. And below 6,300.
What is the total amount?
191.
191,
520.
520. But in the pension payment order, what is the reflection?
After depositing the check amount, the pension payment order was issued by treasury. But that no reflection.
So why the husband of the petitioner did not approach? From 2016 to 21, and wife was not the influence. Affidavit service filing proof is taken on record. So for the state, you are yes. Next paragraph. Husband of the petitioner was a retired teacher.
Yes. Assistant teacher of the academy.
Husband of the petitioner was a primary teacher who retired on superannuation on 31st August 2015. Stop. After superannuation of the petitioner, pension payment on issuing pension payment order dated 1st September 2016. Retirement benefits were released in favor of the husband of the petitioner. Stop. Husband of the petitioner died on 21st July 2020. Stop. After the date of the husband of the petitioner, now after the date of the husband, after date of husband, petitioner being wife of the pensioner has approached this court with the present petition, claiming refund of rupees 1,91,520, since the same since according to the petitioner, said sum was wrongly deducted as alleged excess drawn amount from the petition. Stop. The learned advocates representing the state respondents has opposed the prayer of the petitioner on the ground that husband was pensioner who retired on 31st August 2015 and died on 21st July 2021, whereas pension payment order was issued on 1st September 2016. Stop. After receiving, before receiving pension payment order, the husband before receiving pension payment order, the husband deposited excess drawn amount with the concerned respondent authorities for processing the pension for processing his pension case. Stop. Husband did not approach any husband did not approach respondent authorities during his lifetime, though he remained alive from 1st September 2016 till 21st July 2021. It is the wife who has approached this court after the death of the husband. Stop. Next paragraph. The learned advocate representing the state respondents has also disputed the prayer of the petitioner on the ground of delay, since after release of retrial dues on 21st on issuing pension payment order on 1st September 2016. During the lifetime of the husband, writ petition was not filed, and after death of the husband on 21st July 2021, writ petition has been filed on 7 July 2022. So, next paragraph. The learned advocate representing the petitioner has placed reliance on the judgment of the Supreme Court reported in 2008, volume 8, SCC 648, within bracket Union of India versus Tarsem Singh, bracket close, in order to give explanation of delay, since it is a matter relating to release of literal dues and there is no accrual of third-party interests. Stop. In addition thereto, reliance has also been placed on the judgment of the Apex Court reported in 2015, volume 4, SCC 334, within bracket State of Punjab and others versus Rafiq Masi, within bracket Whitewasher, bracket close, and others, in order to demonstrate before this court that at the time of releasing literal dues, respondent authorities are not authorized to demand refund on the ground of excess drawn. On the ground of excess payment. On the ground of excess payment. Stop. Next paragraph. Having considered the rival submissions, having considered the submissions made by the rival parties, this court directs the Director of Pension, Provident Fund and Group Insurance, being the respondent number 2, to take decision on the prayer of the petitioner to refund the aforesaid excess drawn amount if representation is made by the petitioner within 4 weeks from the date of communication, within 4 weeks from date, claiming within 4 weeks from date, claiming refund. So the respondent number 2 is also is directed to take such decision. The respondent number 2 is directed to take reasoned decision within 8 weeks. Within 8 weeks from the date of communication of the within 8 weeks from the date of receipt of the representation, and communicate the decision within 8 weeks from the date of receipt of the representation, comma, if necessary, after granting opportunity of hearing to the petitioner or our representative. Stop. Next paragraph. The decision to be taken by the respondent number 2 shall be communicated to the petitioner within 2 weeks there. The next paragraph, with the aforesaid direction, the writ petitions shall be disposed of. There shall be no arrest to cost. Next, item number 7. Yes.
There are the claiming interest of applicant area pension under revised Rupa 2009.
Petitioner, assistant teacher of secondary school. Just a minute. Retired on
31st March 2018.
PPO.
First PPO was issued on 24th April 2018.
Revised
PPO was issued on 12 October 2020.
2020. Rupa 19. Issue. Petitioner was the primary teacher who retired on superannuation on 31st March 2018. Stop. After superannuation, after superannuation of the petitioner on issuing pension payment order dated 24th April 2018, retirement benefits were released in favor of the petition. Stop. Next paragraph. In favor of the next paragraph. Stop. There was revision of pay of the petitioner under ROPA 19 rules. Stop. Revised pension payment order was issued in favor of the petitioner on 12th October 2020, releasing benefits under ROPA 19. Under ROPA 19 rules, stop. Petitioner claims interest on revised benefits. Revised pensionary benefits. Stop. Next paragraph. State respondents are represented by learned advocates. Next paragraph. Accordingly, the Director of Pension, Provident Fund and Group Insurance, as well as the Group Insurance and the concerned Treasury Officer are directed to pay interest at a rate of 8% per annum to the writ petitioner on revised gratuity as per revised pension payment order from 14 February 2020 till the date of disbursement of the revised gratuity, within a period of 8 weeks from the date of communication of this order. Rest of the paragraphs will remain same. Next.
Item number 8.
Revised 2019.
Private teacher.
Primary teacher.
Primary teacher retired
28 February 2017.
28 February 2017.
First
First PPO
8 June 2017.
8 June 2017.
Yes.
Revised PPO
7th October 2020.
7th October.
2020.
7th October 2020. ROPA 19. Issue. Petitioner was a retired primary teacher who superannuated on 28 February 2017. Stop. On superannuation of the petitioner by issuing pension payment order dated 8 June 2017, retirement dues were released in favor of the petitioner. Stop. There was revision of pay of the petitioner under ROPA 19 rules, and accordingly, revised pension payment order was issued on 7th October 2020, releasing revised benefits. Stop. Petitioner claims interest on revised retirement dues. Next paragraph. State respondents are represented by learned advocates. Stop. Next paragraph. Accordingly, the Director of Pension, Provident Fund and Group Insurance and the concerned Treasury Officer are directed to pay interest at a rate of 8% per annum on revised per annum to the petitioner, to the writ petitioner on revised gratuity as per revised pension payment order from 14 February 2020 till the date of actual disbursement of the same, within a period of 8 weeks from the date of communication of this order. Rest of the paragraphs will remain disputed.
Item number 9.
Yes.
Yes.
Let's say revised 2019.
Private teacher.
No, there is a group step. No, I'm on state.
You are for the state.
Group step of the high school.
Retired
31st March 2019.
first PPO
1st March 2019.
revised PPO
16 December 2021.
16 December 2021. Petitioner was a non-teaching staff of high school who retired on superannuation on 31st March 2019. Stop. On superannuation of the petitioner by issuing pension payment order dated 1st March 2019, retirement dues were released in favor of the petitioner. Stop. There was revision of pay under ROPA 2019. There was revision of pay of the petitioner under ROPA 2019 rules, and accordingly, revised pension payment order was issued on 16th December 2021, releasing revised benefits. Stop. Petitioner claims interest on revised benefits. Stop. Next paragraph. State respondents are represented by learned advocate. Stop. Next paragraph. Accordingly, the Director of Pension, Provident Fund and Group Insurance and the concerned Treasury Officer are directed to pay interest at a rate of 8% per annum to the petitioner on revised gratuity as per revised pension payment order from 14th February 2020 till the date of disbursement of the said benefit, or till the disbursement of revised gratuity, comma, within a period of 12 weeks from the date of communication of this order. Next paragraph remains same.
Item number 10.
Yes.
Yes.
Husband died. Just in this. On husband died in Handesam.
28 May 2009.
May 2009. Yes.
And PPO was issued 8 March 2011.
Yes.
And now the petitioner is the wise living interest on gratuity.
Let it be considered by the board. Issue. Have you state affidavit service filed filed in court is kept in the record. Next paragraph. The writ petitioner being the wife of deceased, in which post he was working? Husband? Group D. Okay, school. So the writ petitioner being the wife of deceased teacher has approached his court with the present writ petitions in view of death of her husband in harness on 28 May 2009 and claiming interest on gratuity. Stop. After the death of the husband of the petitioner on March 2011, pension payment order was issued in favor of the petitioner, releasing terminal benefits. Stop. Next paragraph. The learned advocate representing the state respondents has opposed the prayer of the petitioner on the ground of delay. Stop. It has been submitted that husband of the petitioner died in harness on 28 May 2009, and subsequently, though pension payment order was issued on 8 March 2011, the writ petition has been filed on 7th July 2023. Stop. Next paragraph. The learned advocate representing the petitioner has placed reliance on the judgment of the Supreme Court reported in 2008, Volume 8, SCC 648, within bracket Union of India versus Tarsal Singh, bracket close, in order to give explanation of delay made in approaching the court. Stop. According to the petitioner, matter relates to pension and no third party interest has been approved. Stop. Next paragraph. In view of the aforesaid submissions submissions being made on behalf of the respective parties. This court grants leave to the petitioner to make a representation to the Director of Pension, Provident Fund and Group Insurance, West Bengal, being the respondent number 2. Respondent number 2. Within a period of 4 weeks from date claiming interest on gratuity. Stop. Next paragraph. If such representation is made within the appropriate time, the respondent number 2 is directed to take reasoned decision on the claim of the petitioner within 12 weeks thereafter. Stop. Stop now, comma. If necessary, comma, after granting opportunity of hearing to the petitioner or representative. Stop. Next paragraph. The decision to be taken by the director of the decision to be taken by the respondent number 2 shall be communicated to the petitioner within 2 weeks thereafter. Stop. With the above direction, comma, the petition stands disposed of, there shall be no less to cost or next, item number 11. So it WPA 1043 2023. WPA 1043 2023, order dated 4th July 2023. Next, 11. Yes, 11. Please. Petitioner was private teacher.
Yes, petitioner is there. Teacher.
Private teacher. Retired on
31st August 2017.
PPO
8 August 2017.
single PPO.
No,
Past PPO
First PPO 8 August 2017.
revised PPO
15 December 2021.
16 December 2020. Issue.
Okay.
ROPA 19. Petitioner was a primary teacher who retired on superannuation on 31st August 2017. Stop. On superannuation of the petitioner by issuing pension payment order dated 8 August 2017, retirement dues are released in favor of the petitioner. Stop. Next paragraph. Stop. Paragraph. Subsequently, pay of the petitioner was revised in terms of ROPA 2019 rules, and revised pension payment order was issued on 16 December 2020. Stop. Petitioner claims interest on revised benefits. Stop. Next paragraph. State respondents who is evidence and state respondents are represented by learned advocate. Stop. Next paragraph. Accordingly, comma, the Director of Pension, Provident Fund and Group Insurance and the concerned treasury officer are directed to pay interest at a rate of 8% per annum to the petitioner on revised gratuity as per revised pension payment order from 14th February 2020 till the date of release of revised gratuity, comma, within a period of 12 weeks from the date of communication, within a period of 8 weeks from the date of communication of this order. Stop. Next, rest of the paragraphs will remain there. Next, item number 12. Yes,
It may be not present on the service not complete.
very well. Then it will be before the next. He is not accepting your service.
I can accept the PD pilot.
Very well. Then place your case. It depends upon the state. If state accepts, then it is always. Petitioner was a private teacher, primary school. Primary teacher, retired
31st January 2016.
16. Then what?
First PPO was issued envelope 16 August 2016.
Revised PPO.
Revised PPO was issued envelope 31st May 2022.
2022.
Yes, 2022.
Ropa 19.
9.
Yes. Petitioner was primary teacher who retired on superannuation on 31st January 2016. Stop. After superannuation of the petitioner, pension payment order was issued on 16th August 2016, releasing retirement dues in favor of the petitioner. Stop. There was revision of pay of the petitioner in terms of Rules 2019, and accordingly, revised pension payment order was issued on 31st May 2022. Stop. Petitioner claims interest on revised benefits. Stop. Next paragraph, state respondents are represented by learned advocates. Next, accordingly, the Director of Pension Provident Fund Group Insurance and the concerned Treasury Officer are directed to pay interest at a rate of 8% per annum to the petitioner on revised gratuity as per revised pension payment order from 14th February 2020 till the date of disbursement of revised gratuity, within a period of 12 weeks. Within a period of 8 weeks from the date of communication of this order. Stop. Next paragraph. Next paragraph will remain same. Next.
Revised 2019.
Primary teacher.
Yes, primary
State. Retired.
about 30th June 2018.
30th June 2018. First PPO.
First PPO was issued in 23rd May 2018.
Revised
Revised PPO 16th September 2022.
16th September 2022. Ropa 19. Petitioner was a primary teacher who retired on superannuation on 30th June 2018. Stop. On superannuation of the petitioner by issuing pension payment order dated 23rd May 2018, retirement dues were released in favor of the petitioner. Stop. There was revision of pay of the petitioner in terms of Rupa 2019 rules, and accordingly revised pension payment order dated 16th September 2022 was issued, releasing revised benefits. Stop. Petitioner claims interest on revised gratuity. Next paragraph, state respondents are represented by learned advocates. Who is acting for the state? Come in front, Mr. Shah. Yes. Accordingly, Common Director of Pension Provident Fund and Group Insurance and the concerned treasury officer are directed to pay interest at a rate of 8% per annum to the writ petitioner on revised gratuity as per revised pension payment order from 14th February 2020 till the date of actual disbursement of revised gratuity, within a period of 8 weeks from the date of communication of this order. So next paragraph, the rest of the paragraphs will be sent. Next. 14.
Statement.
Yes.
Yes. Revised 2019. Petitioner is the assistant teacher of the primary.
Retired on
31st July 2016.
First PPO.
First PPO was 30th December 2016.
Revised
And
PPO.
revised PPO was 12th April 2021.
Ropa 19. Petitioner state petitioner was a primary teacher who retired on superannuation on 31st July 2016. After superannuation of the petitioner by issuing pension payment order dated 30th December 2016, retirement dues were released in favor of the petitioner. Stop. Subsequently, there was a revision of pay of the petitioner in terms of ROPA 2019 rules, and accordingly revised pension payment order was issued on 12th April 2021, releasing revised benefits. So petitioner claims interest on the revised gratuity. Stop. Next paragraph, state respondents are represented. Next, accordingly, the Director of Pension, Provident Fund and Group Insurance and the Concerned Reserve at a rate again 8% on revised gratuity as per revised pension payment. Disposed of. Disposed of 50.
Yes.
Yes.
Petitioner is the librarian of the district library in the district of Coach Bihar.
Yes.
Revised 2019, retired on 30th November 2016.
30 November 16. Yes.
And first PPO was issued on 28 November 2016.
20 November 2016.
And revised PPO was issued on 5th April 2021.
Interest on revised gratuity, ROPA 16. ROPA 19. Issue which for the state?
I'm first.
Affidavit of service. Next, petitioner was a librarian of district library who retired on superannuation on 30th November 2016. So after retirement of the after superannuation of the petitioner by issuing pension payment order dated 28 November 2016, retirement dues were released in favor of the petitioner. So subsequently, there was revision of pay of the petitioner in terms of ROPA 2019 rules, and revised pension payment order dated 5th April 2021 was issued, releasing revised benefits in favor of the petitioner. Stop. Petitioner claims interest on revised gratuity. Stop. State respondents represented. Next paragraph will remain same.
60.
The petitioner is a primary teacher of the school.
Yes. Primary teacher, retired.
28 February 2017.
PPO,
First PPO was issued on 28 March 2019.
revised.
Revised PPO was issued on 28 December 2020.
2020. ROPA 19. Petitioner was a retired primary teacher who was a retired primary teacher. Stop. Who was superannuated on 28 February 2017. Petitioner was a retired teacher. Petitioner was a retired primary teacher who superannuated on 28 February 2017. Stop. After retirement of the petitioner by issuing pension payment order dated 28 March 2019, retirement dues were released in favor of the petitioner. Subsequently, pay of the petitioner was revised under ROPA 2019 rules, and accordingly revised pension payment order was issued on 28 December 2019, 28 December 2020, 28 December 2020, releasing revised benefits. Petitioner claims interest on revised gratuity. Rest of the paragraphs will remain same. Disposed of. You are for the state.
17.
Retired on
Retired on 30th June 2019.
2019.
29.
First PPO.
First PPO was issued on 4th February 2020.
Revised
Revised PPO 25th March 2021.
25th March 2021. Ropa 19.
19.
Issue. Petitioner was a primary teacher who retired on superannuation on 30th June 2019. তার আগে affidavit service থাকছে 30th June 2019 stop. After superannuation of the petitioner by issuing pension payment order dated 5th February 2020 revised by issuing pension payment dated after superannuation of the petitioner by issuing pension payment order dated 4th February 2020 retirement dues were released in favor of the petitioner. Stop. Subsequently, there was revision of pay of the petitioner under ROPA Rules 2019, and accordingly, revised pension payment order dated 25th March 2021 was issued, releasing revised gratuity. Petitioner claims interest on revised gratuity. Releasing revised benefits for us. Releasing revised benefits, petitioner claims interest on revised gratuity. The rest of the paragraphs will be sent before the
18.
Yes.
yes.
Petitioner is the widow of the detained employee. And
This is simply working in which post?
of the
Husband,
husband of the petitioner.
assistant teacher, primary school.
Primary
Just a minute. Died in harness.
No.
Husband retired on
Retired on 29th February 2016.
2016
And the first PPO was issued on
during lifetime of the husband. First PPO.
first PPO was issued on 24th February 2016.
24th February 2016. Revised PPO.
And revised PPO was issued on 5th January 2021.
Revised PPO 5th January 2021. Husband died
Died on 29th December 2021.
29th
December
2021. Rupa 19.
2019.
Issue. Husband of the petitioner was a primary teacher who retired on superannuation on 29th February 2016. Started. After superannuation of the husband of the petitioner by issuing pension payment order dated 24th February 2016. Now, after superannuation on superannuation of the husband of the petitioner. On superannuation of the husband of the petitioner by issuing pension payment order dated 24th February 2016. Pension 2016 terminal benefits were released in favor of the petitioner being wife. Now, released in favor of the husband of the petitioner. Sentence
on superannuation of the husband of the petitioner by issuing pension payment order dated 24th February 2016. Terminal benefits were released in favor of the husband of the petitioner.
So, subsequently, pay of the husband of the petitioner was revised in terms of ROPA 2019 rules, and revised pension payment order was issued on 29 December 2020. On 5th January 2021, releasing revised benefits. Thereafter, husband of the petitioner died on 29 December 2021. Petitioner, being the wife of deceased teacher, claims interest on revised gratuity. Next paragraph, state respondents are represented by manager advocates. Next paragraph, accordingly, the Director of Pension Provident Fund and Group Insurance and the concerned treasury officer are directed to pay interest at a rate of 8% per annum to the writ petitioner on revised gratuity as per revised pension payment order from 20. Husband died much after the return. From 14 February 2020 till the disbursement of revised gratuity, within a period of 8 weeks from the date of communication of this order. The rest of the paragraph will remain same.
90.
Yes. Died hundreds.
Died in hundreds. Who died?
Died.
On
Died on 19 October 2015.
was a teacher,
Teacher.
primary. Then
And the PPO was issued on the
last PPO,
single PPO. PPO was issued on 8 January 2017.
8 January 2017.
8 June.
8 June 2017. Claiming interest on gratuity. State husband of the petitioner was primary teacher who died in harness on 19th October 2015. After the date of husband of the petitioner on issuing pension payment order dated 8 June 2017, terminal benefits were released in favor of the wife being the petitioner. Petitioner claims interest on gratuity due to delayed payment. State respondents are represented by learned advocates. Next paragraph. Accordingly, the Director of Pension Provident Fund and Group Insurance and the concerned treasury officer are directed to pay interest at a rate of 8% per annum to the writ petitioner on gratuity from the date following the date of husband of the petitioner till the date of disbursement of gratuity, within a period of 8 weeks from the date of communication of this. The rest of the paragraph will remain same.
Item number 20.
Yes. We had 2019 petitioner is assistant teacher of the high.
Retired
31st July 2018.
first PPO
16 August 2018. And the
revised PPO
29 December 2018.
29th December
20
Ropa 19 issued. Petitioner was an assistant teacher of high school who retired on superannuation on 31st July 2018. After superannuation of the petitioner by issuing pension payment order dated 16th August 2018, pensionary benefits were released in favor of the petitioner. There was subsequently revision of the petition in terms of Part 2019 rules, and accordingly revised pension payment order was issued on 29th December 2020. Releasing revised benefits. Petitioner claims interest on revised gratuity. Stop. Next paragraph, state respondents, rest of the paragraph is 14 February. Disposed of.
21.
একটা যেমন অন্য মানুষ বলে দিল এটা ওটা ঠিক আছে হ্যাঁ ওই অন্যগুলো সব 14 ফেব্রুয়ারি রিভাইজ করছে
আমাদের পিটিশনার নিতে টা কবে ফাইট না ঠিক আছে
retired on
29 February 2020
29 February 2020
and PTO was 22nd December 2020
22nd
22nd December
22nd December 2020
in the PTO
state affidavit of service. Next, petitioner was a non-teaching staff of a high school who retired on superannuation on 29 February 2020. After superannuation of the petitioner by issuing pension payment order dated 22nd. Now, on superannuation of the petitioner, of the petitioner. But how he will get
1 year delay.
in releasing the same?
Yes.
But the PPO was issued prior to retirement.
No, the PTO was no, PTO was
Yes. We retired on 29 February 2020.
December.
Oh, December.
Yes.
22nd December 2020.
On superannuation of the petitioner by issuing pension payment for a dated
22nd December 2020. Pensionary benefits were released in favor of the petitioner. Petitioner claims interest on revised gratuity due to delayed payment. Stop. State respondents are represented by next paragraph. Accordingly, the Director of Pension, Provident Fund and Group Insurance and the concerned treasury officer are directed to pay interest at the rate of 8% per annum to the writ petitioner on gratuity from the date following the date of superannuation of the petitioner till the date of releasing the gratuity within a period of 8 weeks from the date of communication. Rest of the paragraph will be in same this photo.
22.
I will this number.
After a long time, change the petitioner's advocate. Yes,
Appointed assistant teacher, private school. Superannuated on
just a minute. Retired on
30 April 2019.
30 April 2019. Then
PPO is on
single PPO or revised PPO? PPO
4 April 2023.
yes, claiming interest on gratuity. Yes. State affidavit of service. Next, petitioner was a primary teacher who retired on superannuation on 30th April 2019. So after superannuation of the petitioner by issuing pension payment order dated 4th April, or on superannuation of the petitioner by issuing pension payment order dated 4th April 2023. Retirement dues were released in favor of the petitioner. Petitioner claims interest on gratuity due to delayed payment. Next paragraph, state respondents are represented by the accordingly, Director of Pension, Provident Fund and Group Insurance and the concerned treasury officer are directed to pay interest at a rate of 3% per annum to the writ petitioner on gratuity from the date following the date of superannuation of the petitioner till the date of disbursement of gratuity, comma, within a period of 8 weeks from the date of communication of this order. Rest of the paragraph will remain same. This was only three. One was the email request of gratuity. The assistant editor of my IS. Retired on my 31st January 2023. January 2023. PPO my 24th April 2023. State petitioner was a assistant teacher of high school who retired on superannuation in 31st January 2023. After superannuation of the petitioner by issuing pension payment order dated 24th April 2023, retired benefits were released in favor of the petitioner. Stop. Petitioner claims interest on revised gratuity due to delayed payment. Stop. Next paragraph, state respondents are represented by learned advocate. Stop. Next paragraph, accordingly, the Director of Pension Provident Fund and Beneficiaries and the concerned treasury officer are directed to pay interest at a rate of 8% per annum to the petitioner on gratuity from the date following the date of superannuation of the petitioner till the date of release of the release of gratuity, comma, within a period of 8 weeks from the date of communication of the order. This was the rest of the paragraph in 27. 24. When the Palaya for the people are doing that for gratuity, while a guided hand. Yes. Husband, wife has come. Yeah. Died on my died in Hanes. Yes. Just died on my 5 November 2009. Harness. Yes, ma'am. On 5th. On 5th. They are died on 5th November 2009. 2019. PPO first PO, single PPO. No, no, single PPO. 4 October 2021. You are for the state. Affidavit of service. Next paragraph. Husband of the petitioner was a teacher, primary teacher. Yes, my assistant teacher, primary teacher. Primary teacher. As a husband of the petitioner was a primary teacher who died in harness on 5th November 2019. So, after death of the husband of the petitioner, pension payment order by issuing pension payment order dated 4th October 2021, the terminal benefits were released in favor of wife, who is the petitioner in this present petition. PPO 4th October 2021. Stop. The petitioner claims interest on gratuity due to delayed payment. Stop. Next paragraph. State respondents are represented by learned advocate. Next paragraph. Accordingly, the Director of Pension Provident Fund and Group Insurance and the concerned treasury officer are directed to pay interest at a rate of 8% per annum to the petitioner on gratuity from the date following the date of husband of the petitioner till the date of disbursement of gratuity, comma, within a period of 8 years from the date of communication of the order. Rest of the paragraphs will remain set. I am counting after 5 minutes.
এইবার অনেক ভালো অনেক বেশি
Yes. How much amount? 97,800. Give the details. My lord, it is in a declared on my lord, 28 February 2021. This is 28 February 2021. 28 February 2021. Yes, ma'am. Yes. Which post? My lord, head teacher of Saraswati. Head teacher of primary school. Yes. Deposited the amount on my lord 31st March 2022. And my lord, BPO issued on my lord 8 February 2022. How much amount? Tell me the amount. My lord, 97,080. 80. 80. 80. Show me the treasury challan. My lord, page 19. Let it be considered by the rate of pension. Petitioner affidavit service filed in court dictate with the record. Petitioner was a head teacher of a primary school who retired on superannuation on 28 February 2021. Stop. After superannuation pension payment of 2021. Stop. At the time of processing pension case of the petitioner, she had to deposit excess drawn amount since it was found by the authority that excess payment was made to the petitioner. Stop. Petitioner claims stop. Subsequently, pension payment order was issued on 28 8 February 2022. Stop. Petitioner claims refund of rupees 97,080, which 97,080, which she had to deposit before issuance of pension payment order. Stop. Next paragraph. The learned advocate representing the state respondents has opposed the prayer of the petitioner and has also has opposed the prayer of the petitioner. Stop. According to the state respondents, this aforesaid amount was found to be paid in excess to the petitioner during her tenure. Therefore, the same needs to be refunded before releasing pensionary benefits. Stop. Next paragraph. The learned advocate representing the petitioner in order to fortify her case, has relied upon the judgment of the Apex Court recorded in 2015 for SSC 334 within the state of Punjab and others versus Rafiq Masih White versus close bracket and others. And it has been contended that at the time of releasing superannuation, at the time of releasing pensionary benefits under the garb of excess drawn amount, no amount can be demanded by the respondent authorities. According to the petitioner, she is entitled to get the refund of the aforesaid sum at once. Next paragraph. Having considered the submissions made on behalf of the rival parties, this court grants leave to the petitioner to make a representation to the Director of Pension, Provident Fund and Group Insurance, West Bengal, being the respondent number 2, within a claiming refund of alleged excess drawn amount within a period of 4 weeks from date stop. If such representation is made to the respondent number 2, the respondent number 2 in his turn shall take a reasoned decision on the claim of the petitioner within a period of 12 weeks from the date of receipt of representation after granting opportunity of hearing to the petitioner or her representative. Stop. The decision to be taken by the respondent number 2 shall be communicated to the petitioner within 2 weeks thereafter. Stop. Next paragraph. With the aforesaid direction, the petition stands disclosed that there shall be no order before next. Yes, single petitioner died in hands. Interest of gratuity. Petitioner was a primary teacher. Petitioner husband died in harness? Yes, my died in harness. This is an assistant teacher of high school. Died on just a minute. Died on harness? Yes. 2nd October 2022. 2nd October 2022. Then what happened? PPO is a case of single PPO or single PPO? PPO dated 17 May 2023. Claiming interest on gratuity. Husband of the husband, yes. Affidavit state. Affidavit service husband of the petitioner was an assistant teacher of a high school who retired on who died in harness on 2nd October 2022. So after date of the 2nd September. After 2nd September 2022, after date of the husband of the petitioner, pension payment order was issued on 17th May 2023, releasing terminal benefits in favor of the wife who is petitioner before this court. Stop. Petitioner claims interest on gratuity due to delayed payment. Stop. State respondents are represented by London advocates. Next paragraph. Accordingly, the Director of Pension, Provident Fund and Group Insurance and the concerned Treasury Officer are directed to pay interest at the rate of 8% per annum on gratuity. 8% per annum to the petitioner, to the writ petitioner on gratuity from the date following the date of husband of the petitioner till the date of release of gratuity, within a period of 8 weeks from the date of communication of this order. The rest of the order will be given 7. Disposed of
27. I for the petitioner for getting
I know this is.
single.
Petitioner was teacher.
Petitioner was
Primary teacher. Retired on
30 April 2024.
30th April. PPO. Single PPO. Single PPO. PPO.
PPO 4 May 2020.
Petition, who is for the state? Affidavit of service. Next petitioner was a primary teacher who retired on superannuation on 30 April 2022. So after superannuation of the petitioner by issuing pension payment order dated 4th May 2023, retired dues were released in favor of the petitioner. Stop. Petitioner claims interest on gratuity due to delayed payment. Stop. State respondents are referred to by Hanaka advocates. Accordingly, date of pension provision insurance directly to pay interest at a rate of 8% per annum on gratuity from the date following the date of superannuation of the petitioner till the date of release of the gratuity within a period of 8 months. Rest of the paragraph is within same. This is why. Let me see what is the matter about. Where is the pension payment order? State, nobody is happening. Mr. Shaha, state is not served. At the time of call, learned advocate representing the petitioner has paid for accommodation since service of notice is not complete. Since service of notice of the respondents is not complete. So next paragraph, list the matter before the next circuit subject to convenience in order to enable the learned advocate for the petitioner to complete service. Upon single petitioner was a primary teacher. Primary teacher. Retired on
7th April 20.
7th April.
7 April 2012.
Where you have stated? 7th April 2012.
Yeah.
Yes.
9 June 2023.
You are claiming interest on gratuity. Show me the PPO. Yes, date of retirement 7th April 2020. 7th April 2012. It's not a case of conversion from CPF to GPF.
No,
because pension has been sanctioned from 8 April 2012. 7th April. File your affidavits. It may have happened that after there is a writ petition filed for grant of benefits from the next state following the date of return. There is a revised pension payment order was issued. After issuance of revised pension payment order, now claim is being made. Petitioner was affidavit service filed in court. Next paragraph. At the time of now, the petitioner was a primary teacher who retired on superannuation on 7th April 2012, and pension payment order 2012, and on issuing pension payment order dated 9 June 2023, retired in 2023, pensionary benefits were released in favor of the petitioner. Stop. Petitioner claims interest on gratuity due to delayed payment. Stop. The state respondents are represented by learned advocates who has opposed the prayer. Learned advocate who has opposed the prayer of the petitioner on the ground that there might be some valid reasons for issuance of pension payment order after a period of 11 years, approximately 11 years. The reason for delay in releasing the pension payment order has not been disclosed in the writ petition. Stop. Next paragraph. Let affidavit in opposition to this writ petition be filed within 4 weeks from date, comma, reply thereto if any be filed within 2 weeks thereafter. Stop. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging the affidavit is over. Parties shall act on the server copy of this order downloaded from the official website of this court. Next, yes, petitioner was in a school. Husband died in on which date died?
24 July 2016.
Group T of high school.
Yes, ma'am. Hospital issued
On
5 March 2008.
5th March 2018.
Yes, ma'am.
Revised PPO.
Revised PPO 15 June 2022.
15 June 2022. Rupa 19.
Yes, ma'am.
Petitioner affidavit service who is for the state. Affidavit of service. Next petitioner, husband of the petitioner was a group B staff of high school who died in harness on 24th July 2016. Stop. After the date of the petitioner, after the date of the husband of the petitioner, pension payment order was issued on 5th March 2018, releasing terminal benefits in favor of the wife who is the petitioner. In favor of wife who is the petitioner. Stop. There was revision of pay in terms of ROPA 2019 rules, and accordingly revised pension payment order was issued on 15 June 2022, releasing the revised benefits. Stop. Petitioner claims the interest on revised gratuity due to delayed payment. Next paragraph. Respondents are represented by learned advocates. Next paragraph. Accordingly, the Director of Pension Provident Fund and Group Insurance and the concerned Treasury Officer are directed to pay interest at the rate of 8% per annum to the petitioner on revised gratuity as per revised pension payment order from 14th February 2020 till the disbursement of revised gratuity, within a period of 8 weeks from the date of commitment. Rest of the paragraph will remain same. Disposed of next.
61.
Single. Yes, petitioner was.
Assistant to the primary.
Yes, then
Retired on 28 February 2021.
28th February 2021.
2021. PPO issued on
Single PPO.
Single PPO.
Yes,
June 2023.
state. Mr. Shah, anybody is agree for the state? Yes, petitioner was a primary teacher, period of service. Petitioner was a primary teacher who retired on superannuation on 28th February 2021. Stop. After superannuation of the petitioner, by issuing pension payment order dated 1st June 2023, pensionary benefits were released in favor of the petitioner. Stop. Petitioner claims interest on gratuity due to delayed payment. State respondents are represented by learned advocates. Accordingly, the Director of Pension Provident Fund and Business Unit, the concerned residents are directed to pay interest at a rate of 8 months per annum on gratuity per annum to the writ petitioner on gratuity from the date following the date of superannuation of the petitioner till the date of release of gratuity, within a period of 8 weeks from the date of publication of this order. The paragraph will remain same. Next,
Interest of gratuity single.
died in harness. Husband died in harness.
My lord.
Yes.
Petitioner. Headmaster of high.
On when died?
My lord. 7 June 2021.
7th June 21. 2021.
My lord, PPO issued on 19 May 2023.
Yes, single PPO.
Single.
Claiming interest on gratuity.
Died in hand.
State. Affidavit of service. Next. Husband of the writ petitioner was headmaster of a high school who retired, who died in harness on 7 June 2021. Stop. After date of the husband of the petitioner, by issuing pension payment order on 19th May 2023, terminal benefits were released in favor of wife who is the petitioner. Stop. Petitioner claims interest on gratuity due to delayed payment. Stop. State respondents are represented by learned advocates. Next, Director of Pension Provident Fund to the petitioner on gratuity from the date following the date of husband of the petitioner till the date of release of gratuity, within a period of 8 weeks by the date of communication of the order. Rest of the paragraph will remain then. Yes, 33. Yes.
Assistant teacher primary and retired on
Assistant teacher primary school.
retired on 31st January 2021. And
31st January 2021.
yes, madam. PPO issued on 4 April 2023. Single teacher.
Interest on gratuity.
Yes, madam.
Petitioner, state affidavit of service. Next, petitioner was a primary teacher who retired on superannuation. Petitioner was a primary teacher. Petitioner was a primary teacher. Petitioner was a primary teacher who retired on superannuation on 31st January 2021. Stop. After superannuation of the petitioner by issuing pension payment order dated 4th April 2023, retirement dues were released in favor of the petitioner. Stop. Petitioner claims interest on gratuity due to delayed payment. State respondents are represented by learned advocates. Next paragraph, accordingly, Director of Pension Provident Fund and Group Insurance and the Council Treasury Officer are directed to pay interest at a rate of 8% per annum to the writ petitioner on gratuity from the date following the date of superannuation of the petitioner till the date of release of gratuity, within a period of 8 weeks from the date of communication of this order. Rest of the paragraphs will remain same. Disposed. All other matters.
34. Uttam Kundu. Musantu.
Yes. What is the matter about?
Lord. Related to minor. The petitioner could be the legal option.
Yes, yes. Who is for the respondents? All the respondents are represented? Yes. Every service is complete? Yes, place your case. You are claiming refund of 1/3 of the big money.
Yes.
That is on, that is your only prayer.
Yes.
On what ground you are claiming refund of 1/3 of big
Because
money?
we have completed, we have deposited after being a successful bidder, they had given the
Bidder in respect of what?
in the query
Of the sand query. Sand query. So it was settled in your favor
Yes.
by a bid.
By a bid.
Now the period is over.
Yes, we have deposited everything, but they did not hand over the possession.
When it was settled in, when it was settled in your favor? Query permit. When the query permit was settled in your favor?
In 2016.
2016. So it was settled, but it was not handed over to you.
No.
They deposited the money, they were the highest bidder.
Yes.
In respect of a particular block.
Now it is new auction which is followed.
Yes.
Yes.
E-auction, at that time also it was e-auction. Now the system has changed, subsequent to 2021, the new chairman policy was started. Now what happened here, the entire block, subsequent to that survey, it was found that the entire block is not feasible for mining. A very limited area was found to be fit
for mining.
Yes. So in the list of bidders, the bidders themselves agreed that the bidder number 4 was agreeable to take that portion
do mining activities in a restricted area.
Restricted area. Now they was not agreeable to
first bidder was not agreeable.
The petition.
Yes.
The second and third was also not. The fourth one was agreeable to take handover of that limited area which was available. They have accorded them no objection. Subsequently, we will find from 26 and page 28, the district magistrate wrote to the additional chief secretary for seeking the processing of this proposal so that one particular bidder who is agreeable to do mining in the limited area can be granted the mining lease.
Yes.
In superstition of the earlier proposal.
Yes.
Now, we will find at page 28.
Yes. Just a minute. Page 28.
28. The additional secretary, he has communicated to the district magistrate showing his concurrence, and so far as refund is concerned,
just a minute, let me see.
Yes, please.
Yes. So concurrence of finance department is required.
Page number 33.
Why? Because petitioner being the first bidder has deposited them.
Yes.
It is certain from your submission, Mr. Ghosh, that the query permit is not going to be settled in his favor. Because of subsequent complications with Jaro, and perhaps it may have been or may be settled in favor of the bidder number 3, bidder number 3. So therefore, the mining lease is not going to be settled in favor of the petitioner.
Admitted.
So do you refund the amount?
Yes, Millard, that's what I'm submitting. Page 33, Millard, they have made a last representation. Millard, in a time bound manner, steps may be taken. Because Millard, I say this because once the amount is deposited online, Millard, it goes to the obligor. So that from taking back of that amount from that, Millard,
I will direct the authority to refund the amount, but I will not grant interest. Refund the amount with a certain time. No consideration. I have paid money, Mr. Ghosh, but it has not been settled in my favor. What wrong I have committed? Upon making payment in good faith. Where is that representation?
My lord, from
Who is the appropriate authority to make payment, Mr. Ghosh?
Millard, it would be the district magistrate because in the erstwhile system, the district magistrate was the chairman of the committee. Millard, who is to grant and settle those leases under the manual rules.
my lord, we have
Just. So let me give a direction to refund them.
Millard, since Millard, on written instructions, we haven't received Millard, any Millard.
But
Millard records, there is no other impediment otherwise.
think about
That will
this.
cover.
Think about, yes, I will not record your consent. I will record you that you have opposed the prayer strenuously, but this court has decided to release the amount.
Like, there is no other
Yes,
impediment otherwise, because we don't have Millard written instructions.
Petitioner has approached this court with the present writ petition, praying for refund of bid money. Refund of bid money. Praying for refund of bid money and earnest money. Paying for refund of bid money and earnest money, which he had to deposit at the time of processing his claim. At the time of processing his application for settlement of mining lease in his favor, being found to be first bidder, in connection with mining lease in a plot under jail number 77, PS Naxalbari, District Darjeeling. Stop. Mr. Vikramaditya Ghosh, learned advocate representing the respondents, has strenuously opposed the prayer of the petitioner on the ground that due to certain difficulties which arose after the e-auction, the mining lease could not be settled in favor of the petitioner. Now, mining lease could not be granted in favor of the petitioner, since it was found by the authority that scientific mining could not be possible over the entire piece of land, and a restricted area was demarcated where mining lease was found to be possible. So, after finding this impediments, the authority decided to settle the mining lease in favor of bidder number 4, since first 3 bidders were not found agreeable to carry out mining activities in a restricted manner. Stop. In this regard, notice of this court has been drawn to page 28 of the writ petition, where a communication of the additional secretary, Department of Industry, Commerce and Enterprises, dated 1st October 2020, is annexed, which supports the aforementioned contentions made on behalf of the state respondents. Stop. Next paragraph. Next paragraph, albeit, opposition has been, albeit argument has been made on behalf of the state respondents against payment of, against refund of beat money and earnest money. This court finds on perusal of the relevant documents and in consideration of the submissions made on behalf of the state respondents that in any event, the mining lease is not going to be settled in favor of the petition. Stop. It is indisputable that earnest money and bid money was deposited by the petitioner in expectation of settlement of mining lease in his favor. Stop. Next paragraph. It appears that, where is the representation, page 33? It appears that an application has been made by the petitioner dated 9th March 2023, addressed to the concerned respondent authorities, praying for release of bid money and earnest money.
We have representation made from what? 2020.
Stop. Next paragraph. In view of aforesaid scenario, this court directs the district magistrate, Darjeeling, being the respondent number 4, to refund the bid money and earnest money which was paid to the petitioner in accordance with law within a period of 6 weeks from the date of communication of this order. Stop. Next paragraph. With
There is no impediment.
if there is an impediment, we will take steps before the court. Next paragraph. According to the writ petition stands disposed of, there shall be no orders to cost or the injury of salvage cost. Ability to service filed on behalf of the petitioner is taken on record. Next.
Item number 35.
Yes. Yes, what is your prayer? Service is complete. All the respondents are have been served. Is there any private respondent? No. Yes, that's okay.
Is a school teacher of a particular school. During his continuation of his service, also the petitioner aspired to pursue his PhD course.
What you are claiming, PhD increments on
Increment. The problem is that the school authority is not giving a formal accord to pursue his PhD course.
Have you served upon the school authority?
Yes.
Show me the service upon the school.
Online
Online service.
somebody was appearing in online.
Online. Mostly Bhawal is appearing online. Where is Ms. Mo?
My bedroom. One advocate is calling me that.
देखो तो क्या online में appear करते? Because your grievance is against the school authority.
Yes. No, not the school authority as well as BI and commission.
080 IN sent to Alipurduar RMS MA. It has been dispatched. So, show the service to the state, to the school authority. I am not in a position to find out the service. It is not possible for me. Show me the service that you have served. Because matter was taken up long back on 13 June 2023 by coordinate. Salsabari Model High School, Post Office, Salsabari District, I think this has been dispatched.
The last. Then I have to take up the latest print out.
Next subject. Issue. The writ petition is taken up for consideration when the learned advocate representing the petitioner has prayed for accommodation in order to complete service of notice upon respondent number 7 and 8. Stop. However, state respondents are represented by learned advocates. You are appearing for the state. Learned advocate. Stop. Next paragraph. Acceding to the request made on behalf of the petitioner, list the matter before the next circuit, subject to convenience. Next.
Item number 36. My lord, just to
Let's come.
This matter was led.
36 and it says reopening of assessment. Yes, please. Let me see my own order so that they can read the points.
Order even 3rd July.
Yes.
बच्चाগুলো কি ছিল না যে হেডফোনটা চাই হেডফোনে চাই
Yes, yes, Mr. Madhundar.
Order, you must asking the system wanted to package it deep.
Yes.
But has already, I guess, gone to the publishing. But we say that the acting officer shall, before issuing any notice under section 148.
You are reading 148? A D, right. A, capital A, small d. Yes. Decide on the basis of material.
Materials available on record, including the reply,
of the SSC whether or not it is a fit case to issue a notice upon under section 148 by passing an order with the prior approval of the specified authority within 1 month from the end of the month in which the reply referred to clause C is received by you, where such no reply is furnished within 1 month from the end of the month in which the time or extended time allowed to furnish reply as per clause B expires. My lord. And 148 proceeding is supposed to be taken out against the petition. Now, my lord, may I be permitted to refer to your lordship judgment of all the court?
This will come later.
My lord,
First, satisfy me
my lord,
that, please, Mr. Majumdar, first satisfy me that you have carried out the exercise as contemplated under section 148A, B and C.
my lord, I'm coming to that. If there is any fallacy in
Just from records, you show me that you have carried out. I am not interested to see any order of the coordinate bench. Yes.
When you put the authority under section 148, and you will ask the proceeding to be nullified on whatever grounds he wants.
Will you file your affidavit? I will injunct. I will injunct the proceedings. File your affidavit. At that juncture, I will not. First, Mr. Majumdar, first facts will come first.
Okay, madam.
First, you satisfy me on fact, then I am ready to consider as many judgments as you want to cite.
148A.
Yes, you show me. I have granted you time to satisfy this court that you have followed the safeguards which has been provided to SSC under section 148A, A and B.
Lordship will appreciate the fact that now all assessment process is faceless online from 2020.
Yes.
So hearing will be also through online documents production. No direct hearing can be done.
So show me that exercise has been done.
Yes, sir. The results are in the picture that I have uploaded.
It is your proceedings. You have to because you have opened an assessment.
Lordship.
Now under section 148, under section 148. Now before this is
not open.
Under we have taken a decision. Now you have taken a decision. Now under section 148. Now only safeguard which the SSC enjoys is under section 148A, 148A subsection now 148A, B and C, A and B. Now it is your duty, Mr. Majumdar, since you are appearing, in order to show me that the safeguards and the procedure which has been envisaged under section 148AB has been carried out.
Lordship, the notice was issued upon the petitioner asking him to furnish whatever replies he wants to. So what reply?
Show me the notice.
I will look at page number 30 of my petition. This was the show cause notice which was issued.
Page 30.
Yes. Document we are seeing all these.
Now, this is a notice under section 148 AB. AB. Now, let us read together section 148 AB. Provide an opportunity of being heard to the SSC by serving upon him a notice to so cause within such time as it has been done in the present case, as may be specified in the notice, being not less than 7 days and but not exceeding 30 days from the date on which such notice is issued, or such time as may be extended by him on the basis of application in this behalf as to why a notice under section 148 should not be issued on the basis of information which suggests that income chargeable to tax has escaped assessment in his case for the relevant assessment year and results of inquiry conducted, if any, as per clause A. Now, what clause A says, conducted any inquiry is required with the prior approval of the specified authority with respect to the information which suggests that income chargeable to tax has escaped assessment. Now, B says if it is read in tandem, then B says should not be issued on the basis of information which suggests that income chargeable to tax has escaped assessment in his case for the relevant assessment and results of inquiry conducted, if any, as per clause A. Now, your contention is this, that the inquiry was not conducted. Though you have replied, you have responded to the charge to the show cause notice in terms of section 148 AB, but there was considered a reply of the assessee furnished, if any, in response to the show cause notice referred to in clause B. So therefore, you have given reply to this this notice under section 148 B, 148 AB. C is your reply. Yes. Now you show me the result of this.
Everything was considered.
39 was the order.
No.
There is responses, there is cited case law, everything has been discussed, madam. If they want a cross-examination to be done.
Yes, madam.
That was the condition which is madam.
Page 39.
On basis of the response furnished by the SSC, perceived that the SSC had relied upon various case law. Further, the SSC has also accepted in the written submission the same loan of rupees so and so was repaid along with interest after deducting details. Further, as per information.
Just a minute. Just a minute.
We have just reproduced my reply.
With Kailash Kumar Patwari.
I don't know.
That is the fictitious
Statement of Sri Kailash Kumar. Oh, that is the information which the department
that is
has.
the fictitious deal.
Now, which part of this this document, which starts from page 35, you are relying upon, page 36, you are relying upon.
And also, sir, the 55 is the order. That was given. He was heard, his documents were considered, everything after the exercise was over, it was decided to issue a notice under section 148. He has more.
Where is that, sir, decision to issue notice under section 148? 148.
My lord, same order. This is the order. Starts at page number 35. This is under 148 AD. This is the impugned order, my lords.
So page 35 is an order under section 145 AD.
AD 148
Just a
AD.
minute. But it does not speak about any order AD. Come to 148 AB, Mr. Mujumdar. The assessing officer has received any information.
My lord, can I start?
Yes.
Assessing officer shall, before issuing any notice under section 148, before a notice.
Oh, just a minute. I provided that the provisions of this section shall apply. Oh, this I am reading proviso D. Sorry. Just a minute. So according to you, this is an order under section 148A. Now, how you are affected? Where you are on what basis you are taking the point that safeguards under section 148A has not been complied with?
My lords, see, firstly, my lords, the information which was received by them was from a third party. It was from DTIT Kolkata. Now, the information, if you see, my lords, there is no specific allegation regarding me concerning with the two companies. They have uttered the name of the company, but there is no allegation against me. So this is a general and a vague allegation. This cannot be
whether this information,
yes,
which the department has received, based on which department has initiated a proceeding under section 148. Now, this information was not supplied to you.
No, and I specifically requested them, and at last day, my lord, how to reply. My information has given to me, how it is making sufficient. My lords,
where you have stated that information has not been supplied.
And my lords, even if I don't ask for it, they have
no. Where you have stated that information has not been supplied.
Page number 34, my lords. Page number 34 is my reply.
Yes, where you have stated.
My lords, see this.
Show me that you have taken this point. The information which has been received by the department has not been divulged.
The last part. It is apparent from your notice that the said Kailash Patwari did not say that our transactions were bogus and not genuine. We like to request you to provide us with the copies of the statement received, recorded under section 131 of our Act for our examination also. We request you to provide opportunities to cross-examine. Before taking, and my lords, one more thing, my lords, one more thing, my lords.
Then the whole faceless thing goes.
When the assessing officer will direct him to cross examine. Otherwise, the very purpose of section 148
hearing means he has to go to the portal because it is not face.
No, please come to. I am not concerned with online hearing or offline hearing.
Yes.
But the provisions of the statute have to be complied with, Mr. Mojumdar. It is not so fatal that if it is online process, then the petitioner will not get the opportunity to present his case. Then shun the online process and allow the petitioner to appear before the assessing officer for going whole of the proceedings.
That is a consideration.
Yes, come to section 148A again.
Conduct an inquiry required.
Yes, please read it.
With prior approval of the specified authority with respect to the information which suggests that the income chargeable to tax assessment.
Yes. Now think about the situation. Department has received a communication from Patwari. Now, after receiving communication, if this information is not divulged to the assessee, then how he will come back? How he will reply to the query of the assessing officer? Under the garb of online proceedings, these things cannot be ignored.
Every information was given to him. One page reply.
Show me that this communications or these letters of Kailash Kumar Patwari has been divulged to the petitioner. Show me from your records.
Then I have to go for a letter to disclose all the documents.
Very well, I will direct the authorities to proceed with the proceedings, to conclude the proceedings, but not to pass any final order with the leave of the
My lord, one more thing. My lord, he has all the evidence to be in his proceeding.
No, here I have
whatever
Mr. Chaudhuri, there is this Mr. Mojumdar is there. I have certain reservations with regard to this submission which you are making. Because the provisions of the statute has to be followed truly and in strict sense. Why? When you are crossing the hurdle of section 148A, that stage is over.
Yes.
Now you are entering into the arena of section 148, where the assessment has been opened.
Yes.
So the parameter and the ambit of the proceedings under section 148A, under section 148A is completely different. Here, both of you may be expert in this field. I am not expert in revenue field. But the thing is this: on mere reading of these provisions, it appears that Yes, assessing authority is authorized and entrusted with the responsibility to open the assessment if it is found that an income chargeable to tax was not disclosed to the assessing authority. But there is a safeguard which has been provided under section 148, which requires to be followed stricto sensu. Now that has not been followed in the present case, as prima facie it appears, because the assessing officer initiated the proceedings on the basis of certain information which he has received from Kailash Kumar Patwari. For the sake of compliance of natural justice, the information which assessing officer has received from Kailash Kumar Patwari is required to be supplied to the petitioner in order to provide opportunity to the petitioner to present his case. So if you are in a petition,
actually it is not that we heard it from Kailash Kumar. Under section 132, search and seizure was conducted not in West Bengal but in a different state, in the residence of Kailash Kumar Patwari. There are certain documents where we came across certain documents which their name
shows that the income chargeable to tax was not
disclosed.
Now, if the formation of your opinion as it appears is based on certain materials which are available before the assessing officer. These materials are required to be disclosed to the petitioner.
Yes, it has been disclosed, my lord.
Show me that it has been disclosed.
My lord, as your lordship proposes that we will, that order be passed, we will file an affidavit that the we will not publish the final.
Yes. That will no one more thing. Enough is enough, Mr. Patwari. Mr. Lakotia, not Mr. Patwari.
My lord, I think this is the third or fourth revenue time that I am handling. Both the order will be
Same. Yes. In the writ petition, Mr. Lakotia, when I will dictate, indicate the particulars. In the writ petition, order passed by the assessing officer, order passed by the This is ward number 1 Siliguri, it's on page 45, assessing officer has passed order. Yes, Mujumdar. Page 45, this is the order of under section 148A, page 35. Page 35. Yes, this is an order of the assessing officer. Yes. In the writ petition, order passed by the assessing officer under section 148A within bracket D, capital A within bracket D, under the Income Tax Act 1961, as well as the proceedings which has been initiated under section 148A and B, is under challenge in the present writ petition. No, in the writ petition, is under challenge. Is under challenge. Stop. During course of hearing, the learned advocate representing the petitioner has drawn attention of this court. Yes.
Lordship, if I am permitted to draw the lordship's kind attention, there is a case there, appeal proceeding on setting.
My lord, this is not an appealable order. And this is only the High Court I can raise jurisdiction issue, my lord. There are several cases of that.
My says that there are several judgments of this one.
Yes, my lord.
When there is an alternative remedy, you go to that.
No, my lord.
Where is the appeal proceeding?
Lordship, I don't know whether my lord contains that. It is faceless appeal scheme 2020.
This is not an appealable order, my lord. In my humble submission.
148 is the thing.
No, my lord. No. I can appeal after the assessment order they are passed, then I can appeal, my lords. 148 AD I cannot appeal. This is clear, my lords.
148.
I am challenging 148 AD, my lords, this writ petition.
Show me that there is an appeal provision.
Yes, sir. Let me order the part. I will provide.
Aki বলছেন during course of hearing the learned advocate representing the petitioner has drawn attention from this court.
Notice dated 30th March 2023 issued under section 148 A within bracket small b of the said Act of 1961. In 1961, it was a hearing after referred to as the said Act of 1961. The grievance, next paragraph, the grievance which has been ventilated in this in the writ petition, that by issuing order dated 19th April 2023 under section 148A within bracket D of the said Act of 1961. The respondent authorities, the revenue authorities, has entered into the arena of section 148, has entered into an arena of section 148, whereby the past assessment has been opened. The past assessment has been reopened on the allegation that certain income of the petitioner being assessee was found to be chargeable, was not disclosed at the material point of time.
Escaped assessment.
As a result whereof the said income of the assessee had escaped the assessment. Stop. Next paragraph. While attacking the order passed under section 148 under section 148A of the said Act under section 148A within bracket small d, reliance has been placed on the safeguards provided by the statute under section 148A within bracket small b and 148A within bracket small c. Yes.
Mine was also, I'm relying on the circular, which I showed you the previous day.
Yes.
It's at page number 46.
Stop. 148A within bracket small c. In addition thereto, petitioner has also relied upon a departmental circular, which is dated 1st August 2022, wherein it has been provided that before issuing an order under section 148 AD within brackets small d, the 148 AD, an inquiry is required to be carried. Stop. Mr. Mojumdar, learned senior advocate, Mr. Sudipta Kumar Mojumdar, learned Deputy Solicitor General, has defended the steps taken by the Revenue Authority and has relied upon the order passed by the concerned Revenue Authority under section 148 AD. And it has been demonstrated before this court that elaborate order has been passed by the concerned assessing authority, assessing officer before issuance of the said impugned order dated 19th April 2023. According to the Revenue Authority, the procedure which is required to be followed under section 148A within bracket small b and within bracket small c has been complied with. Next paragraph. Having considered the rival submissions made on behalf of the respective parties, it appears It has been contemplated under section 148A and 148A within bracket B within bracket. Small a small b, 148 capital A within bracket small b, that before passing an orders under 148AD, inquiry is required to be conducted by the revenue authority and an opportunity of being heard, an opportunity of hearing needs to be provided to the assessing concerned. From perusal of records, it appears, where is your reply?
Page 34.
Reply, it appears that the petitioner, on perusal of the reply of the petitioner dated 17th April 2023 to the show cause notice, it appears that petitioner has specifically requested the assessing officer to supply copies of statements of Sri Kailash Kumar Patwari, based on which the concerned assessing officer decided to initiate a proceedings under section 148A, and finally an order has been passed under section 148A within bracket. Today there is nothing on record which goes to show that the statements made by said Kailash Kumar Patwari to the state semi-stable court.
Today there is nothing on record which goes to show that the statements.
Which goes to show that the information which has been provided by said Kailash Kumar Patwari to the assessor, to the concerned revenue authority, has been disclosed to the petition.
My lord, sir, information was supplied by DTIT, another department. It was not supplied by Kailash Patwari.
Then
it was supplied by DTIT Kolkata, stating that Kailash Patwari conducted search, and out of the search we got the statement.
The statements were provided to you?
No, not. I have showed you, my lord. Statement, they are given an extract which is a general and a vague statement. There is no reflection. There is nothing relating to me, my lord.
Very good.
Today there is nothing on record which goes to show that the information which has been provided by the state Kailash Kumar Patwari to the concerned revenue authority has been disclosed to the petitioner
by the assessing officer. Since it has also been submitted on behalf of the revenue authority, that there are certain materials based on which there has been formation of opinion by the concerned revenue officer that a portion of the income of the petitioner remained unassessed. It appears to this court that the materials based on which the opinion was formed by the assessing officer needs to be disclosed to the petition. Next paragraph needs to be disclosed to the petitioner in contemplation of the provisions as provided under section 148 capital A
B
within bracket B and D.
B and D.
Yes. Now A, B and D. A, B and D. 148A within bracket A, within bracket B, within bracket C. Within bracket C, not D. Next paragraph. In view of aforesaid scenario, this court, though permits the revenue authority to conclude the proceedings under section 148A, but not to pass final order without the express leave of this court. Stop. Next paragraph, let an affidavit in opposition to this writ petition be filed within 3 weeks, within 4 weeks from date, reply thereto if any be filed within 2 weeks thereafter. Stop. List the writ petition, and the petitioner, the party shall be at liberty to mention the matter before the appropriate, before the circuit, before the next available circuit for hearing of the writ petition after the time fixed herein above for exchanging affidavits. Stop. Next paragraph. Parties shall act on the server copy of this order downloaded from the official website of this.
I was liberty to mention.
Already I have given liberty after the time.
47.
I have some changing.
Just a minute, you get the changes. Same order.
Why not in this case? To be candid, I did not specifically ask for information, but I am relying on their circular which states that information has to be provided. I have annexed a circular in this petition as well, my lord. It is at page number 95, my lord. 16, point number 16. 95.
But inquiry they have conducted.
Inquiry is not conducted.
Yes.
This is a vague, same case, my lords. Information was not supplied to me. And show cause notice, they have expanded, my lords. The word used is must, my lords.
Dates of order under section 148D and the show cause notice is sent.
No. First show cause notice, then my reply, then the D order.
No, the dates of show cause notice and the order under section 148AD is same. So far the previous writ petition is concerned.
No,
different.
no.
Very well. Tell me the dates.
10th March is the 148B, my lord, show cause notice.
148AD. That is the final order.
First show cause, my lords. 10th March. Final order is 10th April.
148AD order is at 10th April.
My lords. 23.
April 2023.
Yes.
Page.
My lords, it's at page number 86, my lord.
Yes, page 86. And where is the show cause notice?
It's at page number 25, my lords.
Page 25.
Yes.
But there is weakness so far this matter is concerned. We are not asked for the
my lords, but there is specific in their guidelines, my lords, their department
information provided by
whatever information they are relying on, that must be provided to me. Otherwise, how will I file my reply, my lords?
Mr. Mojumdar, I am not injuncting the proceedings. You are free to conclude the proceedings, but not to pass final order with the leave of the court. Let the proceedings be concluded.
Several documents were given to them.
No, my lords. I dispute this.
My learned friend will now submit whatever I have done is vague, is out of the track. Even I may be a vague person, but that was done. And the reply that they give, my lord.
Where is your reply?
My page number 28.
Without information, a 3-page reply was given.
My lords, in my reply, I have specified regarding the transaction which they were asking me to. All the documents.
These are all cases related to bogus.
My lords, kindly share it. My lords, I satisfy you, my lords. I will
file your affidavits. No entry more.
My lords, kindly, my lords.
No.
My lords,
since I am taking the point of violation of natural justice.
One thing, my lords, one thing, just one thing. You kindly allow me to submit my notes. Kindly see page number 86, my lords. Kindly
Come back at
148B order. Okay, ma'am. Sure.
No, same order cannot be passed in this matter. Unless until you have satisfied the query of.
I'll satisfy you, ma'am. Great.
Yes.
Continuing matter, item number 37.
Yes.
Let's come to page number 26. This is the show cause notice, 148A notice.
Where is your reply?
My reply is at page number 28. My lords, I want to indicate that allegations were raised regarding one social group.
But you have not prayed for supply of the information which has been provided by the.
I can see to that.
Very basis of giving you a protection in the previous matter is your reply to the show cause notice.
My lords, but
that ingredient which was there in the previous matter is absent in the present case.
My lords, I'll tell you something.
So where is the violation of principal conciliation? Because 41,
I'll tell you, my lords,
because 148 AD speaks about detailed inquiry.
My lords, see the circular, my lords.
Is it your case that no inquiry was conducted under section?
No inquiry was conducted. And my lords, also in the final order, my lords, they have relied on experience documents, my lords. That was not supplied to me. Kindly take page number 90, my lords. This is the impugned order.
Where you have stated that no inquiry was conducted?
I have not stated that.
Then,
my lords, it's a law point, my lords. It's a law.
No, it's a question of fact. It's a point on fact. It's not a law point. Inquiry was conducted or not, it's a mere fact. Where you have stated in your sorry. Let me direction for filing affidavits. Inquiry, the steps taken by the authorities shall abide by the result.
My lords, kindly take page number 90, my lords.
Sorry, you can't think on this. The writ petition is taken up for consideration wherein the order passed by the revenue officer, by the assessing officer under section 148A within bracket small d close bracket of the Income Tax Act of 1961 is under check. Stop. According to the petitioner, the steps which were required to be taken under section 148A, capital A, 148A, capital A, under A, B, and C. Have not been even according to
Some of the steps which were required.
according to
petition. The steps.
no according to the petition of the proceeding according to the petition of the proceeding under section 148A, A, B, C.
Steps.
Going to the pensioner procedure.
Procedure under section 148 A, B, and 148 A, then A, B, C has not been complied with. As a result whereof, the order dated 10th April 2023 passed by the assessing officer under section 148A within bracket B is untenable. Next slide. Well, Mr. Modundar, Learned Deputy Solicitor General, has opposed the prayer of the petitioner and has drawn attention of this court to the notice dated 10th March 2023 issued under section 148 capital A within bracket small b, whereby it was informed to the petitioner that income chargeable to tax for the assessment year 2019-20 has escaped assessment within the meaning of section 147 of the said Act of 1961. It also appears, it has also been submitted that such steps taken under section 148 capital A were based on information received by the revenue authorities. According to the revenue authorities, after complying the procedure under section 148 capital A, a detailed order has been passed under section 148 capital A within bracket B. Therefore, the contention of the petitioner that principle of natural justice has been violated does not survive. Next paragraph. This court, while appraising the submissions made on behalf of the respective parties, has considered the reply of the petitioner the reply bears no date.
My lord, it's 22nd.
Where?
22nd March.
Where from you are getting this? Here, come to page 28.
I know, my lord, that is not there, but
This it is undated reply.
my lord, actually it is uploaded online.
Yes.
This could, while appraising the submissions made on behalf of the respective parties, has considered the reply of the petitioner.
Petitioner has considered the undated reply of the petitioner, which is annexure P2 to this petition, in order to find out whether petitioner made appropriate deliberation before the assessing officer on receipt of notice under section 148A, capital A, within bracket. Stop. However, on perusal of this, for perusal of the said reply, it does not appear that petitioner prayed for supply of relevant materials based on which opinion was formed by the assessing officer to initiate proceedings under section 148 upon negating the contention of the petitioner by passing of order under section 148 capital A within bracket D. Stop. Next one. In view of aforesaid, now in above prospectus, let me dismiss the petition.
My lords, kindly. My lords, kindly take the impugned order then, my lords. In the impugned order, they have expanded the show cause notice, my lords. They are relying on, I'll show you, my lords, they are relying on.
In above contentions, let an affidavit in above conspectus, in above conspectus. Accordingly, this court finds that the issue needs to be decided. The issue involved in this petition needs to be decided after calling for affidavits. Stop. Let affidavit in opposition to this petition be filed within 4 weeks from date. Affidavit in reply thereto is anyway filed within 2 weeks thereafter. Stop. Parties shall be at liberty to mention the matter before the next available circuit. After the time fixed herein above for exchanging affidavits. Stop. Next paragraph, parties to act on the server copy of this order downloaded from the official website of this court.
Item number 38.
Lord, I beg to appear on behalf of the petitioner, but unfortunately my video has been paused by your lordship's officer.
Yes.
Yes, I think it's now open. Yes. My lord, the petitioners, if your lordships kindly, my lord, look at the cause title, they have, lord, owner of 0.73 acres of land in RS plot number 460 in the district of Darjeeling. Now, lord, originally this property belonged to one Lakshmi Narayan Agarwala, and lord, he owned, lord, a higher area of land. Please come to page 34. The lordships will find that, lord, he owned about.
Yes. Yes. Mr. Paul.
Pleasure. Now, lord, kindly come to page 34. Lord, I'm being assisted by Mr. Amulesh Roy.
Just a minute, Mr. Paul. Let me go through the prayer first.
Yes. I'll.
Yes.
Now, Lord, please come to page 33 for a moment. Lord, your lordships will find that this is, Lord, a record of right.
Page 33.
my lord will find the name of Lokhinarayan Agarwala at the bottom, at the bottom of this page. As the person in occupation. Lokhinarayan Agarwal. Has your lordship found that?
Yes.
Please turn the page, come to page 34. Your lordships will find in Dag number 460, he owned 4.51 acres of land. On the right hand side, your lordships will find the area of the land, and on the left hand side, the Dag number.
Area is 4.51 acre.
Yes. Originally, he owned about 4.51 acre.
Yes.
Now, Lord, what happened is the part of the land was acquired, Lord, by the state of West Bengal, and part was acquired by the National Highway. Now, Lord, your lordships may kindly come to page 65. This is, Lord, a letter from the government.
Yes.
Dated 4th February 2020.
Yes.
And your lordships will kindly come to the second paragraph. It says that as per RS record, plot number such and such, Mouja such and such, was in the name of Lokhinarayan Agarwal with total area of 4.54 acres. Has your lordship found that?
Yes.
And then it says that acquired area, your lordships will find 3.33 in the box, Lord, just below. 3.33 acres.
Out of 4.51 acres.
Out of 4.51, 3.33 acres was acquired by requiring department, agricultural marketing department. Has your lordship found that? On the right hand side?
Yes.
Yes. Then, Lord, 1 acre, your lordships will find Ministry of Road Transport.
Yes. So it comes to 4.33 acres.
Yes. But Lord, when the award was passed, if your lordships kindly come to page 80, this is the award. Then come to page 104. It starts at page 80. Or rather, Lord, kindly see from page 103. My lord will find description of land. Has your lordship seen the description of land which is acquired?
Yes.
Please turn the page. Kindly come to 460. Second entry. Page 104, second entry.
Yes.
Lordships will find 460 eastern, which was 3.33, was reduced to 2.78.
3.33.
Reduced to 2.78. On the right hand side, your lordships will find that the correction was incorporated. There are two columns. One is acre, the other is hectare. Your lordships may kindly see at page 103.
Yes.
One is acre, one is hectare.
Hectare.
So, Lord, kindly see page 104 once again. Your lordships will find the acre was corrected as 2.78, and hectare was corrected as 1.1250.
How hectare was corrected? 1.50.
Kindly see 1347.
Against 460 against plot number 460. Yes.
Yes. 3.33 and 1.3476. These were the original entries.
Yes, these were struck off.
Both are struck off. Yes. And plot 2.78 is written on the right hand side.
Right.
And just below 1.3476, your lordships will find 1.1250.
Yes.
This is the hectare. So, Lord, what was acquired is 2.78 plus 1 acre. So 3.78 was acquired out of 4.51.
3.78.
Yes, Lord. Yes. Leaving 0.73 acres. Now, Lord, what happened is that this gentleman had transferred, Lord, his share of 0.73 acres in favor of two gentlemen in the family. One gentleman and a lady in the family by gift. And Lord, by reason of their gift, Lord, they mutated their name. Kindly see page 53 once. Page 53.
Just in front.
Yes.
Page 53.
Yes. your lordships will find this is a certificate of mutation in favor of Vidya Agarwal. Has your lordship found that? At the top, it's Srimati, it's a certificate of mutation, page 53.
Yes, page 53.
My lord, kindly see top, it says certificate of mutation. This is immediately after the page number.
Yes.
It says certificate of mutation.
Yes.
And then, Lord, it says Vidya Devi Agarwal. Has your lordship seen that?
Yes.
And Lord, it says, if your lordship just come down the schedule of land to the schedule of land, it says kindly see plot number 460 and area is 0.55 acres. Has your lordship found that?
Yes.
So, Lord, this is Vidya Devi Agarwal. And next page, kindly, Lord, come to page 54. This is Lord Devaki Nandan Agarwala. Has your lordship found that?
Yes.
And Lord, schedule of land would show 0.18 acre. So, Lord, 0.55 and 0.18. This is Lord the 73 acres, which was the retained land of Lakshminarayan Agarwala, was transferred in favor of these two persons.
Deepak Nandan Agarwala and Vidya Devi Agarwala.
Vidya Devi Agarwala.
Yes.
And Lord, their gift deeds, your lordships will find at page 35 to 39 and Lord 43 to 50.
What we are paying for, Mr.
Lord,
Boss?
I tell your lordship, there is a private land. These 0.73 acres have now been transferred to the petitioners. Lord, page 8, I have given Lord the various documents by which Lord I have got.
Who have transferred this private land to the petitioners?
The private, those two owners.
That Vidya Devi Agarwala and Devaki
DN
Nandan.
Agarwala. And DN Agarwala has transferred Lord this property to us. And
What
Lord,
is the total measurement of this land? That is 0.55 and 0.18.
Yes, it's total Lord 0.73.
0.73.
The petitioners are jointly holding this property. It's a private land.
Yes.
Now, Lord, your lordships will find that these names of the petitioners are also Lord mutated in the records of the municipality. Your lordship, records of the government. Your lordships may kindly come to page 55.
Yes.
Or rather, Lord, yes, page 55. 55 onwards, your lordships will find that these names have been included. The petitioner's name have been included.
But Neemchand Mitruka.
This Neemchand Mitruka was one of the purchaser. He has died. Now he is represented by his heirs. And Lord, kindly turn the page. Your lordships will find the page 57, Jagdish Prasad Agarwal. He is the petitioner number 1. And so on and so forth. Your lordships will...
They are the joint owners of this 0.73 acres.
Yes, they are the joint owners. They have jointly purchased this property and they have got their names mutated. Now, Lord, your lordships will find the mutation, Lord, runs up to page 63. And then, Lord, 64 is their evidence of paying the municipal tax.
Now, what happened?
Now, Lord, what has happened, your lordships will be surprised. Kindly, Lord, come to page 120. Suddenly, Lord, one day they find that, Lord, this board has been put up in their property.
Site for SMC?
Yes, Siliguri Municipal Corporation.
Yes.
And then, Lord, they made a representation saying that you are encroaching upon a private property. This representation, your lordships will find at page 121 and 122.
Yes.
Now, Lord, after this representation is made, Lord, at page 123, now, Lord, kindly see, the site changes, the signboard changes to site for government land.
Yes.
Lord, there is no acquisition proceedings, nothing, and government's letter, I have shown your lordships at page 65, clearly says that who has acquired what land. Page 65, kindly see. The agricultural marketing is already existing.
Yes, who is appealing for the private state respondents? How this can be?
Subject to correction, since this is taken up for the first instance today, motion state. Let there be a field inquiry and demarcation by the BLLR. As per the record of rights and whatever has been recorded, to ascertain physically whose land or where the signboard has been put up, whether it's a.
Yes, Mr. Kaur, your learned friend, Mr. Ghosh is submitting that let there be a field inquiry by appointing a surveyor of concerned.
I don't know,
Block land and land reforms officer in order to make a demarcation of the land.
for whom is he appearing?
He is appearing for the state response.
The state has no stake there. Later, they're there at page 65. How are they interested in getting the demarcation, etc.? This is Siliguri municipality who is doing the mischief. And I'm really concerned. I kindly not call for an affidavit first and pass an order of status quo as of today. Because, Lord, I don't want to lose possession to a public authority, Lord, who want to trespass into my property.
In spite of giving direction for affidavit, Mr. Kaur, if you are since you are suggesting or you are submitting that the Siliguri municipality is the appropriate authority and who has done the mischief, then the direction can be given upon the Siliguri municipality to appoint a surveyor and make a measurement and come back with a report. In the meantime, let the status quo be maintained.
Lord, status quo should be maintained, but Lord, if there is any Lord effort to find out Lord the area which is vested, Lord, it should be done by the DM. Let the district magistrate Lord undertake this.
No, they are not saying that it is vested or not vested. Today, the signboard. Just a minute. Today, the signboard was there. As you have drawn notice of this code, page 120, the site for SMC. That is municipality. After the presentation, the signboard has been changed and it has been stated that a government land.
Yes.
So this court should pass an order directing the concerned state respondents to make a demarcation and come back.
Lord, first,
by way of a report.
May I submit this with humble Lord humility? I say that Lord, when the government has set up, Lord, I don't know who has set up this board. If the government has set up a board, the government must be convinced that this is my land. How are they not asserting their right in respect of the land?
Learned advocate representing the state respondent is saying let there be a demarcation. After
demarcation for what?
After serving notice to the petitioners, let demarcation be made and a report be filed.
With greatest of respect again, demarcation of what? I have got 0.73 acres of land. That is my property. Why should I demarcate with somebody else? There is no question of any demarcation. The agricultural market committee has already set up. They have demarcated their area. This is totally outside the purview of my property. The highway authority.
Allegation is there is an encroachment on what basis the statutory authorities of the state respondents are making this encroachment. That can be revealed by way of a demarcation.
Demarcation, there is no question of any demarcation. I am saying it is already demarcated. My property is my property. Nobody else has right in that. So they have to first file an affidavit, establish their rights.
Let it be revealed first by way of a report.
Very well. Call for a report. I agree. Call for a report and kindly see on the basis of the report, let there be an order of status quo in the meantime.
Let a report be filed.
Yes,
Mr. Kaur doesn't want that his land to be demarcated at the present moment.
Yes.
Let a report be filed by the Siliguri Municipal Corporation as well as the state.
I will just add something to that. Will kindly come back to page 65 once.
Yes.
Page 65, put 5, plot number 460.
Page 65.
Yes, 460. This is the plot number which is in dispute. Now, immediately on right of that,
page number 65, plot number 460.
460.
Yes.
And the total area is 4.51 acres.
Yes.
Now, as Mr. Kaur submitted, and as it appears from records, the petitioners are concerned with 73 decimals of land.
Yes.
Out of this entire 4.51 acres. Now, apparently from the records, we find that there are other interested parties on the plot as well. The regulated market committee number 1, The National Highway Authority who has acquired some portion of land, good, bad, indifferent, it is admitted. 3, the petitioners, they claim they have 73 decimals of land within these 4.60 acres. Board has been put up by the Siliguri Municipal Corporation, allegedly. And another allegation, government has, someone has said it is government.
So it is replaced.
5%.
From page 65, it appears that out of 4.51 acres of land,
yes,
4.33 acres of land has been 3.33 and then 1 acre.
Regulated market company.
Yes, then the Ministry of Road Transport, it comes to
1.00 by the Ministry of Road Transport.
it comes to 4.33 out of 4.51.
Yes.
Then Mr. Kaur has drawn attention of this
Correct,
court
73.
that it was corrected later on
Yes.
and changed.
Yes.
Area of the land was changed. It was come to page 104
Yes,
against 4.60. Yes.
Now, apparently, it's a plot which comprises a large chunk of land on which there are interested parties. So, without having a demarcation, we don't even know whether Mr. Scott's client are possessing that particular area, which was not.
When you file a report,
Yes,
you
that's
will
what
get
we
the
have
details.
seen that the block land and land reforms officer, I don't know whether there's a better party.
No. At the present moment, you file a report first.
Yes, but the demarcation has to be done by an authority, but BLRO is not a party. He would have been the competent authority.
And who are the private respondents?
If you want to analysis paragraph 10I and 10K, I mean, it is totally based on apprehension. There is nothing else, no application against me.
Paragraph 10.
10I and 10K.
Paragraph 10I and 10K.
Page 20. 20.
Necessarily, they are included as a participant.
Analysis 10K. There is a real apprehension.
Just a minute. Yes, Mr. Kaur, you have made allegations against the private respondents too.
Lord, I have made allegations because, Lord, I am aware of the ground situation as to what
You have
is going to
expressed
happen.
your apprehension that if the National Highway Authority removes them, in that event they may encroach.
Correct. And that is the reason.
Why you are shying away from having the demarcation of your land?
There is no question of any demarcation, Lord. No authority who are the acquiring authority or requiring body are coming forward to say that I need to demarcate. My property is 0.73 acres. What I apprehend is in the garb of, Lord, this demarcation, further complications will be created. And this is what precisely, Lord, my learned friend appearing for this
One
case.
thing in the air, this court cannot direct the authority to file a report unless until the demarcation of the land of 0.73 acre is made.
May I just humbly submit something? Lord, all the other requiring body and acquiring body have got their property. They have constructed, they have made their construction. So, Lord, the property is now demarcated to 0.73 acres. Now, Lord, in my writ petition, they cannot, Lord, seek an order to demarcate and measure my property. I am saying, Lord, they should be restrained from encroaching the property. They have put up a notice board that it is government's property. They must come and tell the court that there must be a right on this property so far as the government is concerned. Why they are fishing and roving and making a fishing and roving inquiry? They have to assert their right on the basis of whatever document they have. And your lordship has rightly asked them to file a report first, saying that what is the basis on which you have put up this board. This is the whole thing. Government of West Bengal coming and saying make demarcation. What demarcation? It is my property. The property is demarcated.
If I may submit this. If I may submit this.
Yes.
considering the entire pleadings to be true and correct. There is a cloud over the title and possessory rights of Mr. God's client.
There is no cloud, absolutely no cloud. You are trying to create one.
State of disposition, the cause of action lies before a civil court. Our court can go into it.
There is no question of any dispute there. You are an encroacher.
By the state government,
State government.
notice which has been put up in front on the land of the petitioner, site for government land.
Well, that's why I am submitting. That seems clear that.
Very well, very well. Let a report be filed. Simply placing, just a notice board, a notice has been put up on the land of the petitioner. That should not. It's a not notice. It's simply one heading, one placard has been placed on the land of the petitioner. That will not be a correct situation directing the authorities to have the demarcation of the land, because on records it appears that it has been, the land has been, the petitioner is having the right over the land in 0.73. A signboard has been put up. Somebody has done this thing. On what basis this has been done? Let a prima facie report be filed before this court. Yes, so. Yes, yes. Let a district magistrate file a report.
Even we have not put up. There is
Either the district magistrate or the land acquisition collector.
And the district magistrate has put up this board. Who has put this board? We don't.
Dispose it of allowing the petition. But there should be a permanent injunction restraining the authorities from implementing the land.
Out of 4.6.
If you disown the steps taken by the authorities, then let me dispose it of granting permanent injunction.
But out of 4.60 acres, which was the demarcated portion which the petitioners have purchased?
Our court wants to hear, wants to see that on what basis this has been done.
All the records are with the land acquisition collector.
There is, according to you, today there is no demarcation. There is no demarcation made. So if there is no demarcation made, and record shows that the petitioner is the owner of 0.73 acres. Now
records have not show. No LR records have been disclosed before this.
Now on what basis there is a rival claim with regard to the interest over the land in question. Over the land in question. On what basis government has poked its nose and saying that by placing a placard that this is the government land. On what basis this has been?
That's the reason precisely why I am praying that
no demarcation at this stage. The issue centers around 0.73 acres of land under tag number 460, Mr. Kaur.
Yes, Lord. Yes.
460. Under tag number 460. Mouza Mondolguri, Mandlaguri. Police station, Siliguri district, Darjeeling. So, by presenting this petition, petitioners have complained of encroachment of the land measuring 0.73 acres by the state respondents, and in support of the same, attention of this court has been drawn to page 123 of the writ petition. Stop. Next paragraph, it has been submitted by Mr. Jalpaiguri, one senior advocate. Upon placing reliance on the document which is at pages 103 and 104, Mr. Kaur, please indicate the corrections which has been made at page 104.
But kindly come to 104.
Yes.
Your lordships will find dog number 460, that your lordship will find at page 104.
Yes.
460. Then Lord, your lordships will find that in acre it was 3.33, which is corrected as 2.78. And in hectare, Lord, it is 1.3476, which is corrected as 1.1250.
So whether 1.1250 has been acquired by the authority?
It is equal to, Lord, 2.78.
So it will be easier if it is indicated in acre instead of.
Yes. Your lordship.
Has been submitted to Mr. Reliance on the document pages 103 and 4.
That out of total land measuring 3.78. Total land is 3.78 acres.
Proposed acquisition was for 3.33 acres.
3.33. So out of total land measuring 3.33 acres, 2.78 acres have already been acquired by the authorities, and 0.73 acres lies with the petitions. Stop. In support of the contention of the petitioners, reliance has also been placed
The letter of the government is at page 65.
No, on the mutation.
Mutation is starting at page 55 to 63.
Reliance has also been based on mutation certificates, which are annexed from page 55 to page
63
of the writ petition issued by the prescribed authority under section 50 of the West Bengal Land Reforms Act 1955. So, next paragraph. Since an allegation has been made that said 0.73 acres of land under DAG number 460 may have been 60 has been encroached by the authorities. This court directs
but instead of encroached, Lord, it should be attempted to be encroached, because Lord, my allegation is they are trying to encroach.
If it is if this allegation is trying to encroach, then it's a premature petition.
No. By putting the board.
Anybody can put up the board. Petitioner themselves can put up the board and come up with this.
No. Petitioners can, Lord, but Lord, my specific allegation, kindly see my representation.
Make up your mind.
I say that
if you make out a case, then I will not pass any orders.
No, Lord, I'm really sorry. What I wanted to say that your lordship has said that they have encroached. I'm saying that they are trying to encroach.
Court is proceeding on the basis of that premise.
Very well. Your lordship can. Very well.
Who is the appropriate authority, Mr. Ghosh, to submit a report?
Below the block land and land reforms officer, who is not a party.
Well, land acquisition collector is there, he is the best person. How much is acquired by, he has the record.
Get to the commissioner, corporation.
The district magistrate is there.
Now we have the district magistrate comes into the picture. What the district magistrate will do? It's the BLR who has submitted a report.
Very well, I will petitioner to add BLR as a party.
To add BLR as a party.
Lord, why should BLLRO be added as party? Because Lord, this is not a case. I am saying that acquisition is complete. The land acquisition collector has full records. Let him file a report. How much has been acquired?
Acquisition is complete with regard to the settlement of land or acquisition of land in favor of National Highway Authority as well as regulated marketing authority. But what is considering today relating to this 0.73 acres of land? That is, your case is that you are the owner of this land. Therefore, if there is an allegation of encroachment, concerned PLR is the appropriate authority to apprise this court whether this land has been, whether any decision has been taken by the authority with regard to the fate of this land.
If my learned friend says that he is the authority, then kindly. Because Lord, I always thought land acquisition collector would have a better information if there is a process of acquisition.
Since the allegation has been made that said 0.3 acres of land under the control section 460 has been approved by the authority, needs for direct.
The block land and land reforms officer. Tell me which PLRO? Who is the appropriate PLRO? Block land and land reforms officer, block land and land reforms officer PLR, block land and land reforms officer Matigara, district Darjeeling, to submit a report in the form of affidavit before the next circuit, commencing from 31st July, possibly from 24. Yes, possibly from 24.
Corridor blocks, that circuit has been extended for.
Now it has not been decided. Commencing from 31st July 2023. Stop. Let the report be let the report be filed. Within 3 weeks from date. Within 3 weeks from date. With an advance copy upon the learned advocate representing the petitioner. So, this the matter before the next circuit on 7th August 2023. 7th August 2023, subject to convenience. Stop. Let status quo relating to the said land measuring 0.73 acre be maintained till 31st August 2023 or until further order, whichever is served. Yes, Mr. Kaur.
Yes, sir.
Yes, yes. The learned advocate representing the petitioners is directed to amend the first title of the writ petition and add block land and land reforms officer Matigara, district Darjeeling, as additional respondent in course of this date, and serve copy of the writ petition upon the added respondent within 1 week from date, enclosing copy of the writ petition and the order passed by this court. Stop. The learned advocate for the petitioners is further directed to file affidavit of service on the adjourned date.
Much obliged. Much obliged.
Yes.
Item number 39.
Why? Let me see. Very good. Yes. At the time of call, learned advocate representing the, at the time of call, accommodation has been paid for on behalf of the petitioner. However, respondents are Gorkha Territorial Administration. However, GTA authority is represented by learned advocates. You are for the states. However, GTA authority as well as state respondents are represented by learned advocates. Stop. This is the matter for further consideration under the same heading before the next slide. Next.
Number 40.
Yes, maybe before the. You appeared in the last occasion and you prayed for time to obtain instruction.
My lord, the once of the petition is that we had 500 rectification subject to correction.
Second rectification application.
My lord, first he filed a rectification under section 54, which was considered and rejected. Subsequently, he files a second rectification. I do not know, my lord, under which provision. Because there is no provision as such to file a second rectification application. And top of that, my lord, any order passed under section 154 of the Income Tax Act 1961 is appeal. There is a secondary appeal.
My lord, there is no bar regarding number of.
Show me the application. Bar, no bar is one thing. But Mr. Lakhotia, place the facts properly. Is there any appeal provision?
There is an appeal provision, my lord, but I am not challenging that.
Show me the appeal provision.
That
I should ask you first. Whether there is any appeal provision. 240.
246.
My prayer was that to dispose of my second rectification.
246. 246 1C. Just Yes, it's an applicable order.
My lords, kindly take 154, section 154, subsection 7. Subsection 7. Yeah,
154 subsection 7.
7 and 8.
Seven is no amendment after 4 years.
That means after 4 years, rectified in number of 150 minus, we do that minus on a regular basis. Well, my completion.
You have made an application for rectification.
Minus.
An order has been passed.
Yes, my lord.
What is the scope of filing the second rectification?
Minus.
Since there is no expiry of 4 years.
My lord, so let me say that this is not maintainable. They
No,
cannot file as per
court is asking you, what they will say, I am not bothered. The court is asking you, come to section 154 for the understanding of the code. The section 154, subsection 7 says, save as otherwise provided in section 155 or subsection 4 of section 186. No amendment under this section shall be made after expiry of 4 years from the end of the financial year in which the order sought to be amended was passed.
Yes, my.
Which means now your contention is this: you have filed a rectification application under section 154. Now this was rejected
During the corona period.
This was rejected.
Yes.
Now does it give right to you
Yes, my.
file another rectification application? There is since 4 years as referred to in subsection 7 has not expired.
Yes, my lord, I can do that. As per the statute, I can.
Then what will happen to the appeal commissions, which has been specifically called?
The first, my lord, kindly consider this, that the first rectification order which was rejected by them, it was a non-speaking order, my lord. I could have filed an appeal, my lord, and I am not submitting that there is no appeal provision, but I filed the second rectification application. That was under law, my lords. And as per
Strange that law, that you are entitled to get an opportunity by way of filing a rectification application.
my lord, subsection 7 does not create a bar in filing multiple 154 applications.
Think about the situation. What is the contemplation under section 246 appeal provision? Just a minute.
My lord, then let me take you to the merits then, my lord, of the case. I will show you, my lord.
This court will not enter into the merit unnecessarily. No, if you can satisfy the query of the court, then court will enter into the merit. But when the preliminary point has been taken, you have to cross that hurdle. Then court will definitely, if it is necessary, court will enter into the merit of the case. Just a minute. Come to page section 246.
Yes, sir.
Let us read the statute together.
Well, I'm not disputing
that. 246.
I'm not disputing that.
Then see an order under section 154 or section 155 having the effect of enhancing the assessment or reducing a refund, or an order refusing to allow the claim made by the assessee under either of the said sections is an appealable order.
Yes, my lord.
Now you have rightly made an application for rectification under section 154 in connection with a particular assessment or assessment made by the revenue authority. Now this was been negated, this has been spurned. Now after the same has been negated, there is an appeal provision couched under section 246.
My lord, but the time
246.
expired, my lord.
No, this is
the time.
time limit.
Yes.
Suppose today I pass an order.
Right.
There's a time limit of 30 days for preferring an appeal before the division bench. Now, whether within a period of 30 days you can, on the self-same cause of action, you can approach the single bench. Since time limit has not expired.
I will kindly consider that the prayer is very innocuous, my lord.
Innocuous prayer is not the answer to this query, it's a question of procedure. When appeal is a substantive provision, Mr. Lakotia. It is a substantive provision. Under section 154, when an order has been passed and an appeal provision has been provided under section 246 C, then can you again approach the same authority? Yes. Which authority has refused it? Yes. It will be an ideal formality.
My lord, then kindly consider this. My lord, kindly give me liberty to file a petition. Kindly state that time limit.
Yes.
In that case, if you kindly give me liberty to file a petition. No, my lord, this can be
extend the limitation since they have approved the petitioner has approached the court. Let me extend the limitation period and let the
Only the period that he has spent in prosecuting this petition may be excluded.
That will serve the purpose.
How will it survive, my lord? My order is passed.
My
I showed you my section. There is no bar in this section. I can file multiple 154 applications, my lord. This is done in
how much time is here?
Why not it is within share 150?
Where is the order passed under section 154?
My lord, it was what demand was passed in 2019.
You made a rectification application. How it has been disposed of? Show me the order.
My lord, first rejection order is at page number 105. That is what I wanted to show you now. This is the computerized form, my lords.
There is order dated 13th November 2020.
Yes. This is midst of Corona, my lords.
My lord, that Corona period was waived off by the Honorable Supreme Court. He could have approached after that.
My lords, kindly give me liberty, then my lords, I file appeal.
After the judgment of Honorable Court.
My lords, let me take you to the let me place you to then, my lords.
Where is that that 4 months period or the limitation period is there?
60.
Where it has been provided under section 246. In my book, it has been provided under section 246(1) that before the first day of June 2000. It's an old book. No. Where is the limitation, Mr. Modular? For pressing an appeal.
Another scheme 49 is the.
Every appeal chapter shall be the prescribed form and shall be very.
249.
Watch it. In the manner which shall in the case of the commission.
Another scheme 49 subsection 2.
Just a minute. You have to read section 246 subsection 1 along with section 249 subsection 2 capital A, Mr. Lakotia. First come to section 246. Subject to the provisions of subsection 2, any assessee aggrieved by any of the following orders of an assessing officer other than Joint Commissioner may appeal to the Deputy Commissioner Appeals before the first day of June 2000 against such order. That was relevant at that point of time. Now 246 section 249 2A says, notwithstanding anything contained in subsection 2, where an order has been made under section 201 or after the first day of October 19, no, this is not coming. What is the provision for condonation of delay or limitation? That after, if the appeal is presented after the prescribed period, that the delay can be condoned if the appellate authority finds it necessary.
Subsection 3.
Yes.
The commissioner appeals may admit an appeal after.
Which section?
249 subsection 3. The commissioner appeals may admit an appeal after the expiration of the period if he is satisfied that the appellate and the commissioner are not presently within that period.
An open provision, Mr. Mudali, it is an open provision. That means in some matters you will find that the appeal provisions, appellate authority is given power to condone delay up to the period of 30 days or 60 days. And so far, 249 is concerned. It is open provision.
Yes, after the
Yes, up to that. So therefore, condone the delay since yes.
Let him go before the appeal.
Yes.
One thing, last thing. There is a CBDT circular, my lord.
Now, if statute prescribed that as to a certain extent, period can be condoned beyond the period of limitation, then there is one effect, one ramification. But if statute says that the appellate authority is empowered to condone the delay up to any extent, like the division bench of High Court, in that event, it is open to the appellate authority to consider the delay. To condone the delay and consider the appeal if it is presented within certain time.
Well, they will dispose.
My lord, may I
As per to let them go and appeal if the company
My
can
lord,
satisfy the commission.
may I submit this, my lord?
Yes. Yes, Lord.
My lord, one thing, my lord, one thing. This is the department's FAQ by CBDT, in which they say you cannot submit a revision of the rectification request, neither can you withdraw it. Once submitted, you can file another rectification request. It is their department's FAQ, my lord. Kindly see this.
No, FAQ will not do.
My lord, this is their department's.
Court will go by the statutory
But
provision.
after statute, I have the liberty to file second rectification as well, my lord.
No. Applicable, it says applicable orders come to 246C. An order under section 154 or section 155, 154 having the effect of enhancing the assessment, reducing the so and so to allow the claim made by the assessee under IRS. So therefore, 246C shall apply in your case.
Okay, my lord, then allow me, give me the liberty to file appeal. That is noxious prayer.
The statute provides.
This court of,
The statute provides a remedy. He doesn't need any leave from remedy.
In the written petition, comma, inter alia, comma. Order dated 13 November 2020. Order dated 13 November 2020 passed by the concerned revenue authority. Whereby rectification application made by the petitioner under section 254 or 154, under section 154 has been rejected, comma, is under challenge. Stop. Petitioner submits, next paragraph. Petitioner submits that after dismissal of rectification application under section 154, we go through 154 of the Income Tax Act 1961, herein after referred to as the State Act of 1961. State Act of 1961.
Made by the petition on 154 by the Income Tax Act, hearing after concerned revenue authority, whereby rectification application made by the petitioner under section 154 of the Income Tax
Act 1961. Herein after referred to as the State Act of 1961.
Is under challenge.
Is under challenge.
Petitioner submit that after dismissal of rectification application under section 154.
A second rectification application has been made under the said provision, and prayer has been made for disposal of the second rectification application by the concerned revenue authority. Stop. During course of hearing, Mr. Sudipto Mojumdar, learned Deputy Solicitor General, has opposed the prayer of the petitioner in view of subsistence of an appeal provision under section 246 within bracket 1 subsection 246 1 within bracket small c of the said Act of 1961. According to the Revenue Authority, the order passed under section 154 rejecting the rectification application of the petitioner is an appealable order. Therefore, second rectification application is not maintainable. Next paragraph, having considered the submissions made on behalf of the parties and on perusal of the relevant provisions of the said Act of 1961, it appears that against the against the rejection of rectification application filed under section 154 of the said act of 1961, appeal lies before the appellate authority under section 246 within bracket 1 within bracket small c. Stop. Next paragraph. It is tried law that where efficacious alternative efficacious speedy remedy is available, the writ petition questioning the appellable order ought not to be entertained unless a case has been made out in the petition, in the writ petition, that there is gross violation of natural justice. Next paragraph. In view of aforesaid, now in view of next paragraph, in view of subsistence of appeal provisions under section 246 within bracket 1 within bracket c against the order passed under section 154, the prayer of the petitioner for giving direction upon the concerned revenue authority to consider the second rectification application, cannot be countenanced. However, in view of existence of appeal provisions under section 246, subsection C, petitioner shall be at liberty to prefer an appeal against the order dated 13 November 2020 before the appellate authority, semicolon, if such appeal is filed within fortnight from date, along with an application for condonation of delay, the appellate authority shall consider the condonation application sympathetically in consideration of the fact that petitioner has approached the High Court with the present writ petition. Stop. It has been made clear that delay in approaching the appellate authority shall not be a relevant consideration in entertaining the appeal if the same is filed within the aforesaid, or if it is filed within fortnight from date. Next, accordingly, the writ petition stands disposed of. There shall be no orders to cost or danger of settlement.
Same order for the next time.
Yes. Any confusion?
Reason of that if within fortnight the
from day
today, then the delay in approaching the appellate authority will be of no consequence. Then my lord, 246 subsection 3 entirely removes.
Why? Because under section the provisions which we have shown, section 249. That's given
249, 246.
That's given. Section 246.
249(3).
249(3). Yes, come to section 249(3).
May I admit an appeal even after the expiry of the period if the commissioner.
So that therefore court has directed that if appeal is filed within fortnight, in consideration of the fact that the appeal, that the petitioner has approached this court with the present petition, while entertaining the appeal, the delay in approaching the appellate authority shall not be a relevant consideration. Let the appeal be heard on merit.
Then means my lord is almost virtually.
Yes. Yes.
Great.
Yes, that I have done.
Next item, same.
But my lord, there is one predicament we will be facing after 4 years from the date of assessment here. We cannot recover. This is the ploy they keep on filing case after case, appeal after appeal. So once the 4 years goes, where they say that after the appeal period, you have to pay this to the government. You 4 years time, but
My lord, my bank account has been freezed by them.
the bank account, bank account and
This is not a.
this is the share that completely. And my lord, there are 3 stages we can't recover after, in some cases after 4 years, and in some cases after 6 months, and some cases after 10 years.
It is a case where after 4 years you cannot recover. So it's an assessment, a matter relating to assessment year of 2020.
No, my lord, 2018 and 2019. In one it is 2018, in one it is 2019. And in one it I just make my rendezvous subject to correction by it is around 18,000 rupees or something like that.
Yes.
19,680.
Yes.
Is the difference amount?
The amount that was
of demand.
That was demand.
Demand.
No, 19. You want to pay 90,000 rupees.
No, I was supposed to get a refund by me.
They want all amenities, good roads. Right from every rooftop.
Then if this embargo and this predicament is there, then this line should be deleted. Let the application along with section 5 application or condonation of delay application be heard by the appellate authority, keeping in mind and decided by the appellate authority sympathetically as it has been held by the court in the previous paragraph, considering the fact that the petitioner has approached the High Court with the writ petition, with this writ petition. And delay is not a relevant consideration. We like it.
Yeah. Next item, some.
Just a minute. Otherwise, there will be a difficulty at the time of correction. Yes. So that Mr. Motundar, please wait.
41.
These are the nuances of revenue matters. Because if there is an embargo that the case cannot be reopened after 4 years or no recovery or no, then there will be a difficulty in the matter of allowing the application for condonation of dealing in preferring the appeal.
Well, let them show some provisions.
You show the provision of 150.
No, they are saying, my lord, that there is embargo. Let them show which provision there is an embargo. Yeah. Let them place the relevant provisions, my lords. Which provision, my lords? Please ask them to show, my lords.
There is no provision that you are benefited. Then how will you?
If such appeal is filed within fortnight of that along with applicant for condonation of delay, the appellate authority shall consider the condonation application sympathetically.
Shall consider the application for condonation of delay. Shall consider the application for condonation of delay.
Delay application sympathetically in consideration of the fact that petitioner has approached the High Court with the present petition.
Yes, ঠিক আছে। তারপর
it has been made clear that delay in applicating the appellate authority shall not be a relevant consideration in the appeal if the same is filed within the if the same is filed, then even
if the same is filed within the period of fortnight. এটা কেটে দাও। Shall not be a relevant consideration. এটা কেটে দাও এই সেন্টেন্সটা।
relevant consideration.
It
has been made clear that delay in appraising the appellate court shall not be a relevant.
It has been made clear থেকে present. Yes.
The dates needs to be changed now.
Yes. Only the date of the order.
Date of the order, reply, yeah, order
Other things I have not stated in my. Which page? The order under section 154. Page number 115. The rejection order. 25/11/2020. 150. Yes. Is an application under section 154. Same issue.
Similar matter.
Order dated 25th November 2020. প্রথমে দেখবে যে অর্ডারটা বলা আছে না আন্ডার সেকশন 154 ওইটা 25th November 2020 Just a minute. Next slide. Otherwise it will remain same. Should be take up include order grade 21st. This one. Next. 42.
Today application for before the revision.
Yes, it's an habeas corpus application. It should be heard by the petition bench. Why it was not pointed out to the court many times? Oh, you do not appear. Nobody appeared for the state. Habeas corpus application can writ petition seeking habeas corpus is not maintainable before the single year. Very let this writ petition be transferred to the honorable division bench for consideration. At the time of call, learned advocate representing the state respondents has admitted that petitioner has prayed for writ in the nature of habeas corpus. Manta again, clear a path. Otherwise, good. Writ in the nature of habeas corpus. For production of petitioner's daughter before the court. Such submission, next part, such contention raised on behalf of the state respondent is not disputed by the learned advocate representing the petitioner. Stop. Next paragraph. In view, since petitioner has since it is a writ petition seeking writ in the nature of habeas corpus, the department is directed to convert the writ petition into a writ petition of habeas corpus. Department is directed to convert the present writ petition into a habeas corpus petition and renumber the same within 7 days, within 48 hours from within 48 hours. Stop. After registering the writ petition as habeas corpus petition, let the writ petition be placed before the honorable division bench, subject to all. Affidavit service you have filed. You have filed any affidavit of service?
Yes, my lord.
Take it back.
My lord, I have already served, my lord, all the.
Very good, very good.
Please consider.
Affidavit of service filed on behalf of the petitioner is taken on. Next.
43. Due to the pendency of the petition, the cause of the petitioner has already been addressed upon. So there is no cause of action of. It may be issued on that time, but however, the other consequential benefit may be taken. I will pass. In a condition.
Consequential?
Maybe because the applicant court of law may be kept open for further cost.
Is it necessary since your grievance has been replaced? Issue. At the time of call, learned advocate representing the petitioner submits that the grievance of the petitioner stands replaced. As a result, whereof the petition is not pressed. Stop. State respondents are represented by learned advocate. Stop. Next paragraph. In view of aforesaid submission made on behalf of the petitioner, the written petition stands dismissed as not pressed. Stop. However, petitioner shall be at leave to approach the appropriate forum in accordance with law. It's not required. Read this. Urgent Xerox. 44. So meaningless. If you have any grievance subsequently, if there is any cause of action, you have every right to approach the authority. Because cause of action with regard to this writ petition has ended.
Item number 44.
What do I take to take What's the thing the similar same?
Just a minute. Yes, what you are submitting?
Actually, the same matter. Just this quarterly pensions have the order to consider the interpretation of the petitioner with the accordance with law.
Where is that representation in representation? Where is the representation here? In the present case, whether any representation has been made.
Page number 19 motion.
Who is the appropriate authority? Special Land Acquisition Collector.
Yes, no.
It should, at the time of call, no one appears to the petitioner and no accommodation is paid. However, state respondents are represented by the learned advocate. The learned advocate, the learned advocate representing the state respondents submits that on similar situation, a coordinate bench passed an order dated 22nd September 2021 on a writ petition being WPA 1281 of 2021 within bracket Purno Chandra Rai versus State of West Bengal and US. So it has been passed by Justice Radhashekhar Mandra. No, it's the same order. I will rely upon this order. So, this court on next paragraph, this court on provisional of records finds that a representation has been made on 31st May 2022 addressed to the concerned respondent authorities for determination of compensation as per relevant provisions of the right to fair compensation and transparency in land acquisition, rehabilitation, and resettlement Act 2013. 2013. In view of the fact that a case has been made out by the petitioner that his land has been acquired by the authority for laying railway tracks. So, next paragraph, in view of the contents of the representation dated 31st May 2022 and the similar issues since has been decided by the coordinate bench in Purno Chandra Rai Supra. This court directs the special land acquisition collector format, which we have to make assessment of to determine compensation payable to the petitioner for acquisition of his land under the aforesaid Act of 2013 within bracket Supra comma, within a period of 12 weeks from the date of communication of this order. Stop. The concerned special land acquisition is also directed to communicate the order to be passed to the petitioner and also to the general manager within bracket construction of Northeast Frontier Railway within a period of 2 weeks thereafter. If general manager, comma, construction. Now, if the general manager within bracket construction close bracket of Northeast Frontier Railway is communicated the order to be passed. Now, the order passed by the is communicated the order passed by the special land acquisition collector to be here. Comma, the state general manager shall take steps in terms of the order of the land acquisition collector special land acquisition collector within a period of 6 weeks from the date of receipt of the order from the special land acquisition collector. Stop. The aforesaid direction, the reputation stands reported, there shall be no orders before surveillance. Next.
45.
Same order.
45 and I'm being under the state. The matters is not with the state transport corporation. State goes legally.
Petitioner is not appearing. What is the matter about?
Here is a seeking release of pensionary. 2,500 this employee was declared as unsuitable. And subsequently, the file did not move. There was a remove from the head office.
Issue. At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. However, which authority were representing?
The state
North Bengal State Transport Corporation. However, North Bengal State Transport Corporation is you are representing NBSTC.
Yes.
North Bengal State Transport Corporation is represented by Lorna. Stop. It appears that on 4th July 2023, matter was taken up, and in consideration of the prayer made on behalf of the petitioner, adjournment was granted, and matter has been fixed for hearing today. Stop. Next paragraph. It appears petitioner has lost influence. Stop. Writ petition stands dismissed. Intimate finish stands vacated. Now, writ petition stands dismissed. Arvind Xerox served copy.
46.
একটা কাজ করো, writ petition stands dismissed for default করে দাও। It will be clear.
I have to say, in this matter, it's a similar matter.
What is the representation? Page number
Page number 9.
page 19. Shono, page 19. ওই আগে যেটা করলাম ল্যান্ড অ্যাকুইজিশন কম্পেনসেশন সেই সেম অর্ডার শুধু রিপ্রেজেন্টেশনের ডেটটা ডিফারেন্ট হতে পারে মিটিং এ দেখো 31st of May 2022 ডেট অফ রিপ্রেজেন্টেশন 31st May 2022 যদি অর্ডারটা পাস করা হলো রিলাইং অন দ্য অর্ডার ডেটেড ইন সেপ্টেম্বর 2021 তাহলে কিন্তু ল্যান্ড অ্যাকুইজিশন স্পেশাল ল্যান্ড অ্যাকুইজিশন সেম অর্ডার ডিসপোজ অফ
47 and 48.
This is item number which has been disposed of 46, 46, 47 and 48. Yes.
Page 7, I'm waiting for few of the respondents. And 48 and the-
Who is appearing for the Siliguri Municipal Corporation? Have you filed a report as directed by this court on 2nd May 2023? Yes. Whether the copy has been given to the learned advocate.
Just received.
See the report.
Yes, sir.
So unauthorized construction has been made and certain deviations has also been made.
Yes. I've just received this copy, Lord.
Yes.
Apparently, This shows that there is nothing illegal.
No, it has been stated details report as here under one unauthorized room constructed at the rooftop measuring so and
This
so.
concerns
The second floor alteration has been made for space meant for kitchen, toilet and veranda. At ground floor cantilever measuring so and so. At the rear side open space and unauthorized toilet block measuring so and so has been constructed.
Alright, coming to the points one by one. Point number
The court is not in deal with that whether by taking the scale, that whether it has been unauthorized or not. So you have to make a deliberation before the appropriate authority. I will direct the Siliguri Municipal Corporation to initiate a proceedings under section 266. This is akin to section 218. Oh, yes. Under the relevant provisions to initiate a proceedings, you will get an opportunity of hearing. You will get an opportunity of hearing. Show me the provisions.
It's 287.
I will not determine that it is an unauthorized construction norm.
I'm not into that.
So therefore, unnecessarily, the writ petition will not be kept pending.
If this report is considered
Shall be disposed of. Both the writ petition shall be disposed of directing the concerned authority of Siliguri Municipal Corporation to initiate a proceedings under the relevant provisions, and both of you will be given an opportunity of presenting your respective cases, and within certain time the proceedings shall be brought to logical conclusion.
Only one thing, Manoj.
Yes.
Only one consideration.
Yes.
A fresh inspection may also be ordered. Because I'm coming to that.
It cannot be only. It is within the domain of the Siliguri Municipal Corporation while initiating the where is
the judgment of a court bench says that all the parties concerned have to be issued.
Yes.
This inspection was not done in presence of all the parties.
Very well. You take this point before the minister. 287. Appropriate proceedings is 287.
The commissioner is.
It should. Pursuant to the order dated 2nd May, dated 6 July 2023, the writ petition being WPA 1082 of 2023 is placed on record, and both the writ petitions are taken up for hearing analogously. Stop. The writ petitioners, writ petitioners in both the writ petitions are represented by learned advocates. Stop. Siliguri Municipal Corporation is also represented by learned. Stop. Matter is heard. Stop. Pursuant to the next paragraph, pursuant to the order dated 2nd May 2023, passed by coordinate bench on the writ petition being WPA 1082 of 2023, a report has been filed on behalf of Siliguri Municipal Corporation, signed by 3 authorities on 20 May 2023, which is taken on. Which is taken next paragraph. On perusal of the said report, on perusal of said report, it appears that the authority, the Siliguri Municipal Corporation, has found certain constructions made by the petitioners in WPA 1082 of 2023 as unauthorized. So, however, at this stage, court is restraining itself from entering into the constructions, the nature of constructions made by the petitioner, made by the petitioners in WPA 1082 of 2023. However, at this stage,
the court is restraining itself from entering into.
The court is restraining itself from delving into
the nature of construction made by the petitioner in WPA 1082 of 2023.
Since next paragraph, since allegation has been made by the petitioners by the petitioners in WPA 10381 of 2023 against the petitioners in WPA 1082 of 2023 that without any sanction plan or permission, constructions have been made by the petitioners in WPA 1082 of 2023. This court finds it apt to direct the concerned respondent authorities, to direct the concerned authority of Siliguri Municipal Corporation to initiate the proceedings under section 287 of the West Bengal Municipal Corporation Act 2006 and bring the same into logical conclusion within a period of 16 weeks from the date of communication of this order. So, however, it is made clear before concluding the proceedings, due opportunity of hearing should be granted to the petitioners in WPA 1082 of 2023 and WPA 1381 of 2023.
So let the notices be set aside.
Next paragraph. The decision to be taken by the concerned authority of Siliguri Municipal Corporation on conclusion of the aforesaid proceeding shall be communicated to the parties within 1 week thereafter. Next paragraph with the aforesaid direction, the petitions can dispose of. They have no orders to cost or then develop separate copy. Yes.
Kindly the notices be set aside because these notices are directly targeted to us, and the observations that have come out in the report.
I have considered it and rested my and has restrained myself from making any further comment. Please call the next matter.
Kindly set aside notes.
Go outside the court and start squaring. Item number 49. It is the job of the statutory authority. Let them take decision. If you have anything to say, it will be communicated to you when you take steps in accordance with the law. There must have been an appeal provision, or you can come to
unauthorized construction that have come out in the report against them. But they are targeting us. That is my only thought.
So that's why opportunity of hearing will be granted to
you. But I can
the
notices they are targeted to us.
No, sorry. Next.
So they next madam
Yes, what is the matter? Compassionate appointment. Whether your application has been rejected. When died? 2002.
No, died on August 2013.
Working in which post?
Working in a group system of a municipality.
Group staff of Mathavana municipality.
Yes.
Who is appearing from the municipality and the response?
Also delivery.
Who is to give appointment? Appointment is to be given by the TLB. Director of local bodies. The state has to be represented. Yes, you are appearing for the state.
But this is an internal appointment.
Internal appointment means not a regular appointment. Show me the appointment letter.
No, internal. I am getting the pension.
Oh, you are getting the pension?
Yes.
Where is the PPO? Yes.
Right. Initially, the wife made an application.
Yes, chairperson.
Yes, chairperson. They have to
The chairperson has to take a decision and forward it to the department. The Department of Municipal
nothing has been done. With 17 at the department.
But nothing is only date come retirement gratuity has been released. What about other parts of pensionary benefits? DCRG date come retirement gratuity has been released, but other family pension nothing is indicated in the pension payment order. Column 9. Yes, yes. Now, where is your application? When page 17. Died on 5th August 2013. It is not readable where you have stated in the petition. Yes, paragraph 3. Working in the post of group D. Now, who is the applicant petitioner?
Now the petitioner is the son. Now petitioner is the son.
At the time of death of petitioner, what was the age of the son?
Major.
Let me see.
Currently,
Have you made director of local bodies as a party respondent?
But I am body of
We have no power. We can recommend that it is. DLB is the appropriate authority. Very well. Let DLB take a decision after granting opportunity hearing to the petitioner as the representative of Matabhanga municipality.
Well, he may be the petitioner may be granted liberty.
Yes, yes, yes. Who is applying for the state? Yeah, you are applying for the state. Petitioners has approached this. Petitioner has come up with the writ petition. Petitioner has come up with this writ petition, claiming appointment on compassionate ground in view of death of his father, who was working in the in view of death of his father in harness, who was working in the post of Group D in Matabhanga municipality, district Kuch Bihar. Stop. The father of the petitioner died on. Oh, stop. After the death of petitioner's father on 5th August 2013, mother of the petitioner made an application on 24th February 2014 seeking appointment on compassionate ground. However, stop. However, stop. It has been submitted that till date no steps have been taken by the concerned respondent authorities on the prayer of the petitioner for providing appointment on compassionate. Stop. State respondents are represented by learned advocate. Stop.
There was by the father of the petitioner.
Yes. Let's see. Having regard to the aforesaid facts, this court directs the director of local bodies, government of West Bengal, to take decision on the prayer of the petitioner on the prayer of the petitioner. Now, to take decision on the entitlement of the petitioner to get appointment on compassionate ground by passing a reasoned order within a period of 12 weeks from the date of communication of this order. after passing the, before passing the resumed order, the director of local body is directed to grant opportunity of hearing to the petitioner and the representative of Matahana municipality. Stop. The decision to be taken by the director of local bodies shall be communicated to the petitioner within 2 weeks thereafter. Stop. With the aforesaid direction, the petition stands disposed of. Stop. Next paragraph, the learned advocate representing the petitioner is granted leave to amend the cost title and add director of local bodies, government of West Bengal as additional respondent. The advocate of the petitioner is also directed to communicate this order along with copy of the writ petition to the director of to the added respondent within a period of 2 weeks from the date of communication of this order, and within a period of 2 weeks, from date, and within a period of 2 weeks from date. Stop. ওটা যে 12 weeks যেটা বলেছি ওটা 16 weeks করে। Stop. ঠিক আছে। Disposed of, there shall be no orders to cause urgent jail. Open for the affidavit of service filed on behalf of the petitioner is taken on record. Next.
Thank you. Item number 50.
Yes. Yes, Mr. Mujumdar. Okay.
Actually, in this case, there is a representation that was given by the petition still pending. So, by about one way, in one view of the matter, it is premature. In another view of the matter, but in my humble view, I could not find any real cause of action for the petitioner to pursue the matter. His representation is on the process of being considered. Till then, he has not been asked for any memo. No memo has been served. I don't petitioner any document where he's been forced to go to his post of place of transfer. He is saying where.
Yes.
But there is no scrap of document, no scrap of paper attached to the writ application, my lord, which will tell us that no, there is a question pressure, there is some sort of pressure upon the petitioner, whereby the authorities are asking him to go and join your new place of post. My lord, on the other day was very, what is from my lord was very correct. That 4 years has to be taken into consideration from his initial date of birth. I am not on that. At least he has to show your lordship some apprehension, real apprehension that we will face. We are not that draconian, my lord.
So that's why he is proposing to pass an order
I understand
directing the authority to
we will consider, my lord. But I'm just asking myself.
I'm not interfering with the order, only the transfer of the order will be
necessary. Whether the reach at all necessary.
Yes.
Whether this ritual does not at all necessary matter. He has not been asked to join, he has not been asked to give. His representation is under consideration. That's what has already been issued. Yeah. But then I don't know when. When? Let the petitioner tell.
Where is your representation? I understand the contention of Mr. Mojumdar. Where is your?
Answer number 9 and 9/1. And also answer 8. 41, 42.
Who is the appropriate authority, Mr. Mojumdar?
39, 40, 41, 42.
Let this representation be considered. About keeping in abeyance the transfer of the petition till the decision to be taken.
I completely out of but I'm just asking myself, was this exercise at the same time?
At the same time, please appreciate the agony of the petitioner.
Might not seen the transfer order.
That I have seen 18 March 2020. 2023.
2023. Till March,
Not 2020.
2023, my lord. March, April, May, June, July.
It's a fight between the lion and the lamb. Try to appreciate.
Well, anyway, the union never loses either the citizen means or the department. So I put the lion and the lamb.
Take a decision. Feel such decision is taken. In the writ petition, transfer order dated 18 March 2023, whereby petitioner has been transferred from what is FTR headquarter? Frontier
Headquarter North.
Frontier headquarter North Bengal to Frontier headquarter Meghalaya by the concerned authority of BSF, by the concerned authority of Border Security Force. However, after having heard the learned advocates representing the petitioner and the respondent authorities, it appears that though transfer order was on 18 March 2020, but till date the same has not been given away, and petitioner has been permitted to discharge his duty in his present post. Stop. Next paragraph. Petitioner has made a representation dated 3rd April 2023 addressed to the Director General, Force. Made a representation to the Director General. Please don't disturb the court in this fashion. I will release the matter.
Petitioner made a representation dated 2023 addressed to the Director
General, Force. It's a Frontier headquarter or Force headquarter? Yes, this is wrongly spelled. Address to Director General, Frontier headquarter, Border Security Force for Force headquarter. Very well. Director General, Force headquarter, Border Security Force for consideration of this prayer against the impugned transfer order dated 18 March 2023. Stop. Since the transfer order dated 18 March 2023 has not been given effective till date, this court directs the Director General, Force headquarter, Border Security Force, being the which respondent? Respondent 2 to take decision on the representation of the petitioner dated 3rd April 2023 within fortnight from date, and the same be communicated to the petitioner within 1 week thereafter. Stop. Next paragraph. This communication of the decision of the respondent number 2, the impugned order of transfer dated 18 March 2023 shall be kept in evidence. Next paragraph. With the aforesaid direction, the representation stands disposed of. There shall be no argument.
Time period, my lord, was.
Fortnight, one.
It was extended or extended to 3 weeks.
Very good. Fortnight টা যেটা বলেছি 3 weeks. Communication within 1 week from the day order to be passed by the day respondent 2 shall be communicated within 1 week. Fortnight টা 3 weeks. Next 51.
Only one thing, petitioner is the marriage daughter, claiming the competitioner. Only one child, other died.
Married daughter, there is a special judgment in favor of married daughter. I was part of that special bench which considered the content matter. So let it be considered. Where is your application when the employee died?
Second April 2030. And my application is.
Mean which paragraph you have stated?
Paragraph 3. Paragraph 4. Second April 2030.
Haldiwadi municipality. Group D staff of Haldiwadi municipality. And paragraph date of death when they died.
Second April 2030.
Where you have stated?
Paragraph 3 below. Petitioner's father after referring that he has typically been filing and I and said that it is 2005.
Paragraph 3.
4.
Where is your application?
Page 25. 24 December 2005.
Page 25. 24.
24 for the mother application and
who is the petitioner?
Petitioner is the
daughter. Where is our application?
Page 20.
Petitioner has approached this court with the present repetition, praying for appointment on compassionate ground in view of death of her father in harness on 2nd April 2013. Father of the petitioner was working on substantive basis in Group D post in Haldiwadi municipality, district Kuch Bihar. Stop. After the date of the employee, you are the married daughter. The married daughter of the petitioner made an application dated 24th December 2013 to the concerned respondent authorities requesting to take steps for providing appointment on compassionate. So, it has been submitted that in spite of making such application till date, no steps have been taken by the authority on the application of the petitioner. No steps have been taken by the authority. State respondents are represented by learned advocate. Next paragraph. Having considered the submissions made on behalf of the petitioner, this court directs the Director of Local Bodies, Government of West Bengal, to take decision on the entitlement of the petitioner being an unmarried daughter to be appointed on being a married daughter to be appointed on center stable.
Having considered the submission made on behalf of the petitioner,
this court directs the Director of Local Bodies,
Government of West Bengal, to take decision on the entitlement of the petitioner being a married daughter,
being married daughter to be appointed on compassionate ground by passing a reasoned order within a period of 16 weeks from the date of communication. Have you made DLB party? Within a period of 16 weeks from the date of communication of this order. Stop. The decision to be taken, stop. Before taking such decision, the petitioner shall be given opportunity of hearing. A petitioner or her representative shall be given opportunity of hearing. Stop. The decision to be taken by the director of local bodies shall be communicated to the petitioner within 2 weeks thereafter. Stop. With the aforesaid direction, the petition stands disposed. Next paragraph. The learned advocate for the petitioner is granted leave to amend the first title of the written petition and add director of local bodies, government of West Bengal as additional respondent in course of this day. Stop. After amending the first title, the learned advocate for the petitioner is further directed to communicate this order along with copy of the writ petition to the added respondent within 1 week from date. Stop. The learned advocate representing the state respondents is also directed to communicate this order to the director of local bodies, government of West Bengal, immediately. Stop.
But the petitioner to serve upon the.
But you communicate.
Earlier petition.
There shall be no orders to there shall be no orders to cost. Urgent Xerox certificate copy. Urgent Xerox certificate copy at the appealing to service filed on behalf of the petitioner is taken on. You communicate since the director is not party.
But in the earlier
That I remember, but I have amended my order for the present writ petition contract.